The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as public records and freedom of information laws. The content may include adult themes, adult concepts, and adult language not suitable for all audiences. For the safety of all, no viewer should ever engage with, interact with, seek out, or contact in any way persons being discussed, including those under criminal prosecution, and especially those that state,
"It's not like I've gone and killed somebody!"
Viewer discretion is advised.
In the city by the bay, where the fog rolls in at night, Laura Owens spun a tale that turned day to bitter fight. Met on an app called The League, oh, the sparks, they seemed to fly. But love turned to a courtroom stage where truth began to cry. She claimed he broke her heart, oh, with a cruel and violent hand. Screamed of bruises, tears, and terror in a story oh so grand. But the texts and emails whisper a different tale they tell of a woman weaving fictions in a self-made private hell. Oh, the restraining order waltz, spinning lies in a legal dance. Laura's pen writes a medium article of faults, taking truth on a wild romance. Michael stands in the shadows, call with the weight of her decree. In this Broadway of betrayal, who will set the truth free? January 8th, the street-side scene where tempers flared and roared. Laura's voice a siren scream as obscenities were poured. Michael called the law that night to report her wild display, but Laura flipped the script by morn with a filing the next day. A temporary order granted, buttons the poodle's name in tow. Her family denied protection, but the drama stole the show. Renewed in 2020, set to linger till this year. A shadow on his name and life, a weapon forged in fear. Oh, the restraining order waltz, spinning lies in a legal dance. Laura's pen writes a tale of faults, taking truth on a wild romance. Michael stands in the shadows, call with the weight of her decree. In this Broadway of betrayal, who will set the truth free? She spoke of pain in a TEDx glow, a stranger's note to save her soul. But the timeline cracks, the stories fold. Her claims a script that's growing old. From Iceland's chill to a courtroom's glare, her words don't match the truth laid bare. A forensic probe, her phone's the key, unraveling lies for all to see. The judge's gavel waits and wings as justice takes its bow. The evidence is piling high, the question's only how. Will Laura's waltz keep spinning on with stories that deceive? Or will the curtain fall at last for those who still believe? Oh, the restraining order waltz, The echoes of this drama linger in this Broadway state of
Welcome, everyone, back to my channel. Welcome to your favorite little cubbyhole on the internet. We're here, folks. Here we are. Here we are. Are you ready to go? I will warn you. Here's my first. Here's my first rant for the evening. I am in a spicy mood tonight. I'm in a very effing spicy mood tonight. I'm out of chocolate. Work did not end today the way I wanted it to, with some difficult clients getting resolved. And Jeep Daddy will be along eventually, so I've got to wing it till he gets here. I'm in a spicy effing mood, to say nothing of all the crap that has happened. To say nothing of all the crap that has happened in the last 48 or so hours. So I will warn you of that right now. I am spicy. That's not good. When I'm out of chocolate and I'm spicy, that is not a good combination. That's like taking away, candy from a baby. They're just going to start screaming. So, hi, chat. I'll breathe for half a second. I'll breathe half a second and say, hi, chat. Nice to see you over here. Welcome, Moose Raiders. It's difficult trying to start a show and get ready for one as you're watching, Bruce finish his. And no, I will dispel the myths of the song. That is not me singing, although it would be something I would write if I were to write such things. No, it is the brilliance of AI music with a lot of, shall we say, coercive input from yours truly. Because I know a little bit about such things. We know a little bit about the arts and about musical things, but lest I leave giant nuggets of meaty substance for my future doxers, that's about all I'm going to say right now. And no, it is not Josh Groban either, although it's it's passable. It's an okay AI voice, but we've got a number of AI musical hits revolving around this case. Yes, I know everyone runs to Megan Fox and says, "Oh, the Megan Fox musicals and all that other stuff that Megan did." And yes, they're fantastic. Megan was first. I will admit to stealing the concept entirely from Megan. I don't have the snake chorus, though, and dare I say, snake chorus is the feather in Megan's cap when it comes to all of the songs about Laura Owens and David Gingras. We've got several songs. If you want to look in the Laura Owens jukebox playlist on my channel, you can listen to some of the others that have appeared on this channel. So there's that for all you music lovers there. Every once in a while I get a snarky comment in the replay crew of someone saying, "Oh, I hate the music at the beginning. I didn't watch any of it." Poof. And I just kind of say, "Well, you have no taste." And then a couple hours later, I delete their comment and block them. I'm spicy, folks. I'm spicy. Oh my God. All right. Housekeeping item number 2. See, I've got to collect myself just enough to run this damn thing without Jeep Daddy to, take a little bit of the edge off while I'm feeling spicy. He'll be along. I'm sure he will. He said he's on his way. Oh my God. Housekeeping item number 2. In lieu of super chats, super gifts, super grifts, all the things where you could send me money, I would be very much honored and privileged if you would send Mike Marraccini money. So for those of you who like QR codes, there's a QR code, and hopefully it works. I updated it earlier this evening. This should take you to the latest with Mike Marraccini's GoFundMe here QR code. And down below on the banner, scrolling by, is a, shall we say, analog version of the same link. So, chat, if any of you decide to give tonight, bless you, thank you for all that. If there's any problems with any of the links, let me know, because I'll be frank, as shitty as my life is right now, and I can say this even for Jeep Daddy and what he's going through working with Corporate Daddy right now, as shitty as our lives are collectively and separately, I'd much rather deal with that crap than what Laura Owens is going to, or going through perhaps. But, well, she did it to herself, so, there's that. Okay, now, oh my heavens, let's start with Item number 1. We have got a metric tons of stuff to cover tonight. I'm going to try and move somewhat quickly because, I'm supposed to stall a little bit for Jeep Daddy, but on the same token, or maybe the other side of the same token, there's a lot to get through tonight. We've got multiple filings with the San Francisco case. That's why I started with the restraining order waltz. I pulled it out of the mothballs just a little bit. Oh, is he hiding? Oh, of course he is. Of course he's hiding in chat, the stinker. Well, he'll be along. I see now he's derailing me in chat. That's the usefulness of Jeep Daddy. Yes. Okay. Item number 1. Let's just get to it. Tempest Fugits. So let's talk about the latest with the plea deal, because that's been kind of the latest breaking news, as it were. And, there's been a little shifting and shuffling about the plea deal. And I'm not surprised. Because this is just kind of an epic shit show. And, no one's in charge. That's kind of how my work is right now. It's an epic shit show and no one's in charge. And if I try and take charge, it's going to be ugly. So there was an initial report, and this was kind of reported by KTAR News, which is some Arizona radio station news channel thing. There was initial breaking news. Schnitzel reported on this and then modified what Schnitzel posted on her YouTube channel. There was a posting or two on the Justice for All Victims of Laura Owens, the @Clayton's Justice Twitter account. There's been some massaging of wording there. The initial report was from Rachel Mitchell that Laura Owens rejected the plea. That has been revised. So now let's just read what this article is from KTAR News. They do have some audio. I'm not going to play the audio right now because the last video where we did something about another crazy fake pregnancy lady in Australia got struck. And that video's now taken down for right now until it finishes editing, and all of the offending stuff from Nine Entertainment in Australia, who flagged that discussion, gets resolved. So that one's out of commission, and I wish not to tempt the copyright doctors too much, but we've got to at least read some things here. And as Bruce rightly says, take charge. Well, because who else is going to run this shit show? I'm it. Hey, Rob. Hey, Rob. How does that work? Hey, Rob. Hey, that works. Hey, girl. Hey, Rob. Hey. Rob says there's another one in Arizona too. Tiffany and I covered it in recent past. Okay. Very good. Thanks, Rob. Big Tiff Dog. Yes. Excellent. So let's just go through some of this. From KTAR News by David Iverson. KTAR.com is the KTAR, if I enunciate that properly, is the website. So this is, we'll just read through this and cover the high points and go through that. There's been a little bit of walking back. Teresa asked me if I can play it. I would, but again, I don't want to get another copyright hit. I just monetized this damn thing. I get too many copyright hits, I'm in trouble. So I'm not going to play the audio on this per se. Not unless I can come up with a way to, I'm avoiding copyright. Thank you, Danny, for that as well. Yeah. So we're gonna read the text and then we'll read the footnotes, because there's a footnote. I was skimming through it during Bruce's video, and it reads as follows: the Laura Owens case. And let's see, can we embiggen slightly? I don't want to admit my age, but there we go. The Laura Owens case could be heading to trial, as so far Owens has not yet accepted a plea offer, according to the Maricopa County Attorney's Office. So far, that's accurate. And as Rob says, I've acted out. Yes, and I will keep acting out until I can't help it anymore, or my adrenaline tanks and I just crash. I turned into a pumpkin somewhere about 1:00 Eastern time. So, I do have my limits. And Rob also says, my Alexa keeps responding every time I see I love it. I should have just used the name Alexa, shouldn't I? Oh, well. What do you do? Maricopa County Attorney Rachel Mitchell was asked about the case on KTAR News 92.3 FM's Outspoken with Bruce and Gatos. And that's who the audio is by. I listened to a snippet of it. I did pre-queue it. They don't say a whole lot because it sounds like Rachel Mitchell's having to look to other people to answer the questions. And then they go on and on about the history. We don't care about the history. Oh, this was about a bachelor and he was on this season. And some people, they go through all of the bachelor crap. And we know this. This is old news to us. Get to the point. Did she or did she not take the plea deal? That's all we care. Just don't bury the lead and get to the point. Okay, Owens, a 34-year-old Scottsdale woman, is facing 2 sets of felony charges in Maricopa County after prosecutors say she faked pregnancies to pursue men for child support, including former The Bachelor star Clayton Echard. So many of them are running with that for child support. Yeah, she did tick that box, but as we know, it was more than just about child support. She wanted to latch on to him. She wanted to be Mrs. Laura Owens, right? I mean, Clayton. Oh, wait.
Clayton, I want you to date me with intention. And if you don't, I'll have the babies tonight. Thanks. All the best.
Yeah, I mean, she wanted to get her little mitts into every guy she ever clung to. She must have sharp talons. That's all I can think of. Oh my God. Okay. Yeah, that's the next step, Mitchell said when asked whether the case would go to trial. She declined to share details of the plea offer, and I heard that in the audio that I sampled. Owens was indicted in May 2025 on 7 felony counts tied to the Echard case, including fraud, forgery, perjury, and tampering with evidence. A second indictment in another fake pregnancy case followed months later, adding 7 more charges involving a different man Owens had briefly dated in 2021. And yes, I'm so spicy, the tankard is full to the brim. If I were a drinking sort, it would be spiked tonight, but I'm not. So it'll keep me out of trouble, and it will keep me from getting any YouTube DUIs, hopefully. Let's see. Boy, they've got all the stuff wedged in the middle of it, don't they? Related stories. Scottsdale woman indicted for alleged paternity scheme against Bachelor star. Scottsdale woman accused of paternity scheme against Bachelor star finds more legal trouble. I just love it. They just insert more stuff. In the Echard case, prosecutors alleged Owens altered an ultrasound image, faked a pregnancy video, and lied under oath multiple times during civil paternity proceedings. Between May 2023 and June 24, Owens dropped her paternity claim against Echard in May 24, saying she had suffered a miscarriage. I'm almost put together. Jeep Daddy is still selecting his favorite bourbon for this evening. I can't remember who it was, but I had a message earlier. Was it today or was it last night? Where someone said they were selecting their adult beverage for this evening's stream. And I responded to them saying, choose wisely, otherwise Jeep Daddy won't approve, or something to that effect. Or maybe I just said Jeep Daddy would approve of their choices. I'm not sure. I can't remember now. Let's see. Owens dropped her claim against Echard in May of 24, saying she suffered a miscarriage. A Superior Court judge later asked the Maricopa County Attorney's Office to investigate. Echard, a Scottsdale real estate agent who starred in season 26 of ABC's The Bachelor, said the indictment lifted a weight of 2 years from his shoulders. The Laura Owens investigation extends beyond Maricopa County. Well, that one is definitely earned. Mitchell also confirmed that while additional allegations have been made against Owens, some occurred outside Arizona and fall beyond her office's reach. But perhaps not beyond the reach of other offices in maybe some other states. Quote, a lot of people are wanting it all wrapped up here, and obviously I only have jurisdiction over what happened in Maricopa County, she said. End quote. Adding that there are some allegations that other things happened as well. The case has drawn outsized attention from true crime podcasters, thank you very much, and social media commentators, also thank you very much. While Mitchell said she doesn't follow the coverage to gather information, she warned against trial by media. However, my rebuttal to that is we are entitled to our opinions because, God damn it, it's America, and we have the First Amendment. And I've been with this case far too long not to have some opinions about where I believe it is headed. And dare I say, 30 years ago, well, now that there's new people, never mind the 40 anything, we have new people like Bacon Bears and Llama and Buffy. And they are, in very short time, much quicker than all of us who've been with this thing since the beginning. In very short order, they have concluded the same thing. They have concluded the same thing. So, folks, even the brand new, fresh as a dewdrop eyes seeing this case, they're all, and bless them, they are racing madly to catch up to today, current events. How can they? Oh, no, they will. They will. They're amazing. Buffy and Llama went for a good 4 hours, and I was behind listening to it because work crap was just falling apart. But I was on 1.5 listening to them and listening to Bacon and Lauren and everybody else, and also Roz and J-Hip. Oh, God help us. I've been flying through everybody's content. And if you want something to stir your feelings, if you have not listened to Megan Fox's latest update and coverage on this case, she had with her Mo in the Deep End, is that right? Mo, Flux, and and Roz on her channel. And the first part of her show was on YouTube. The entirety of it is streamed on Rumble. She covered all the latest with Dingus the Douche Canoe. Oh, damn it. Wrong page.
The fucking douche canoe.
She covered the latest with him, some of the stuff with the ladies, and on the Rumble portion, because I've talked about this a little bit. I have not read the documents on YouTube because the documents of a certain attorney for Laura Owens and his nearly criminal past, they're not quite YouTube worthy, shall we say. Not because the story is not worthy, but because there's so many words in it that the AI bots on YouTube will flag to shut you down. Because when we talk about underaged SA, shall we say, YouTube doesn't like those conversations, as important and as difficult as they are. So if you don't know the story of David Gingras and his past, go and check out Megan on her Rumble. So, there's extra stuff to do. But be prepared. If you want to hear all of that story in the latter half of Megan's coverage, be prepared. Those of you who have things with SA, it's a very hard conversation that the ladies have. It's a very honest and frank conversation. So there's some good stuff out there. They have good stuff beforehand. But if you want to hear the past of David Gingras and have that frame your thoughts as to who he was then and who he is now, those might be informative to you. Again, I have talked about David's past case where he was facing felonies himself. And they dropped the charges against him. He was, after being indicted and some prosecutorial misconduct happened, they dropped his charges. But if you read all of the case file stuff, that's available also on Volo in paperwork form. But if you want to hear Megan and ladies read and discuss that, it's I recommend it. I recommend it, as difficult as it is. So go check out Megan. Go check her out on Rumble. I have sort of joined Rumble. I may at some point multi-stream on Rumble as well as YouTube, because the day will come where I have to deal with YouTube headaches more than I already do. You've heard the stuff. You've probably seen it on Twitter where content creators are getting shut down and demonetized left and right by the thousands from YouTube. I don't know if it's the great conjunction of YouTube and people are just getting shut down. It's a purge, or they're having a YouTube purge. I don't know. So I'm looking at additional options for streaming coverage ability. So I'm looking at that and some other things. I'm thinking about it. Okay. Let's see. What else? Sorry, that was a digression. How did I do? That was a pretty good digression. Yeah, okay, we're over here. The case has drawn lots of outside. Yes, okay. Owen's next hearing is scheduled for September. Is that true? No. I don't think that's true. There's some inaccuracies here. Her next complex case management is happening next month, as I recall. I think it's the middle of the month. And let's see, at the bottom of the story, correction, the story was updated to reflect that plea negotiations are ongoing, just like the RavGen tests are ongoing as well. So, yes, so many things. So many things. Okay, that's enough of item number 1. And yes, as a teaser, folks, as a teaser for you in the first half hour, we will get to some Medium articles, or at least a new one. I may not be in the mood for Gingras articles or blogs tonight. I'm not sure about that. But there will be some Medium stuff. But I want to do this sort of chronologically, and I'm desperate to kind of hold it together because I'm spicy, and there's a lot of there's a lot of stuff that there's a lot of stuff to hold together. Okay, next item. So now let's go to the Marraccini stuff. So let me see. Share this tab. And I'm going to try and do this in order, but we'll see if I can actually manage it. And again, we have the things up there. If you wish to donate generously to Mike Marraccini and his ever-increasing legal defense fund, there's the QR code there. And there's the analog link there. And if you don't like either of those, if you're old-fashioned like I am, folks, there is the cut and paste option in the show notes down below. So you have multiple ways to contribute to Mike Marraccini, should you feel so inclined. And as you would probably notice if you've checked out the page, the costs, not surprisingly, fighting the crazy Laura Owens. And I believe it's more than just my opinion she's crazy. I think in the opinion of many people she's crazy. It's expensive. And it gets nasty. And some of this stuff in text gets nasty. Let's see, do I have hers too? I hope I do. We also have the Kristen Harden Declaration, and let's see. All right. Okay, here we go. Everyone tell Jeep Daddy to hurry up and inhale some food and get his butt on here so I don't have to do this all by myself. All right, and we need to embiggen. And this is the respondent Michael Marraccini's motion for attorney fees and costs, memorandum of points and authorities. And this fires off a neuron in my head already. We'll talk just for a second before I read this, to talk about the latest crap on the Twitters. Yes, I know. Bruce did a brilliant job, by the way. So if you'd like the latest Twitter drama of, oh yes, he's back, David S. Jingras has returned to Twitter. He can't help himself. He's so addicted to all this stuff. He can't help himself. Not only is David Jingras back on the Twitter, but his good buddy and co-counsel, or representation, I'm not sure which, for his bar hearing, Mark Randazza himself, Mr. Free Speech, the captain of free speech in the legal world, allegedly. Representing David Jingras. They both take their shots at everybody, including me. Bruce covers it. I made this is the danger of tagging like everybody in Twitter threads. Of course, he couldn't help himself. So, David fired something off. I made a comment of, it's about time they yank his bar card or something to that effect. And David responds, I'm still here, bro, heart emoji. And then I respond to David sort of. It wasn't a direct response. It was just kind of reply, but he sees him. I reply, I hope you read, well, this isn't verbatim. I hope it's with an ignition interlock device. And then he responded, for your mom's pants. So he runs right to the yo mama jokes. Very bad. And then I fired off one more and I called it a night. Well, yeah, if she's dead, if you like that kind of thing. Ew, gross, David. Leave the necrophilia alone, for Christ's sake. My mother's been dead nearly 30 years. No one wants that with or without an interlock. No one wants it, okay? And, I would sit there, I would give him the shovel and I would get the popcorn and then I would call the police on him trying to dig up my mom just to put a device on her pants. But, she's not buried in pants. That's the thing. Mormons are weird. I've left Mormonism. I'm well over Mormonism. But my mother was married, as Mormons do, in her temple garb. The white clothing they wear to the Mormon temples is part of the weird Masonically plagiarized rituals in Mormonism. So that's what my mother was buried in. So it's not pants. It's weird temple white dress. No one wants that. Ew. Gross. David, stop it. So yeah. That's enough. That's enough on that one. Otherwise, go check out Bruce's latest, and he'll read you all the latest gossip, gore, and details from the Twitters. All right, back to the notice of motion to petitioner Laura Owens in propria persona. From Omar Serrato. Please take notice that on July 2026 at 9 a.m. or soon thereafter, as the matter may be heard in Department 405A of the above entitled court, Respondent Michael Marraccini will and hereby does move this court for an order awarding attorney's fees and costs against petitioner Laura Michelle Owens in the sum of $109,000, $109,633, and because he's petty like I am, 98 cents. Oh, golly, maybe we need a few more of these. The cha-chings are going up with this case, folks. This motion is made under Family Code section, etc., on the ground that petitioner request to renew restraining order was frivolous and solely intended to abuse, intimidate, or cause unnecessary delay, and that petitioner has or is reasonably likely to have the ability to pay the fees and costs sought. Costs are independently sought under Code of Civil Procedure 103, etc., etc., etc. This motion is based on this notice of motion, the accompanying memorandum of points and authorities, and the declaration of Omar R. Serrato and exhibits thereto. The exhibit package filed concurrently in papers and records on file, and such further argument and evidence as may be presented at the hearing. My spice might be taming already because I'm just I'm pissed. All right, procedural history background. 2018 stipulated order. Petitioner Laura Owens filed a request for a DVRO on January 9, 2018. Temporary order issued January 10 of the same year. I'm gonna truncate just slightly. Parties entered a stipulated restraining order after hearing on or about July 10 of the same year. The stipulated order contained no judicial finding that respondent committed domestic violence. The 2020 renewal on July 10 of 20, petitioner filed a renewal request. On September 11, 20, the Honorable Sharon Reardon, Department 403, held a contested hearing at which both parties appeared pro per. That means without lawyers. The court applied the reasonable apprehension of future abuse standard, and granted the request. That's why it happened. Okay. To renew for 5 years. Yeah. This is why you've got to fight them, folks, as expensive as it is. This is why you just can't rest on your laurels with any of this stuff. You have to fight everything, even if it runs you into bankruptcy. The record contains no finding of any DVRO violation by respondent. The 2020 renewal was based on petitioner's subjective statement of fear. The 2025 renewal petition. On July 9, 25, petitioner filed a second request to renew restraining order on Form DV 700. On the form, petitioner left blank section 4A, the box stating, "I am afraid or worried that the person in 2 might abuse me in the future." She marked only section 4B, alleged violations. Respondent retained the Eagle law firm, that being Omar Serrato, on or about, I wonder if he likes eagles. I wonder if he likes eagles. I'm going to have to ask him about that next time we get to talk. It's a curious name for a law firm, Eagle Law Firm. Does he like eagles? Inquiring minds want to know. On or about July 9, 25, between July and October 25, respondent filed a response to the renewal request with 15 exhibits in opposition to petitioner's motion to proceed by declaration, motion to disqualify petitioner's counsel David Gingras, motion to vacate the 2018 order, Code of Civil Procedure 473 motions, and eliminate a trial brief, in opposition to David Gingras' motions to intervene, and for sanctions, witness and exhibit list, and supporting declarations. Should we catch him in incognito? There he is, folks. Look, he's there. Now he's gone. Now he's there. Now he's gone. Now he's there. Are you here, or should I just leave you alone for a while?
Are you done screwing around with the little stage button things, or
You never know with me. I said I'm spicy.
You did, and I am behind on my vino consumption. That's what we're going for today.
Llama went through another bottle on her live. Bless
well,
her heart.
I don't know if I could. I don't know if you could blame me for that one this time.
If I get 5 minutes to myself for the weekend, I need to send some emails to Bacon Bears and to Buffy and Llama at their channel. Mm-hmm. And hey, ladies, we all need to have a kiki. I don't know when, I don't know where, I don't know how, but we just need to do it. And you and Llama can talk about wines, and I don't know what Buffy and I would talk about, and then Bacon Bears. We'll all find something to talk about.
Well, yeah, we've got some commonalities around.
Bruce, how dare you, sir? Bruce says Echoes can't be a bear. Bacon Bears is a bear. How dare you, sir? No, I would like to classify myself, because this question gets floated around. If you were furry, what would you be? I have an answer. It's not a bear. I would be a marmot. I'm trying to start a new class. I want to be a marmot.
Who's out there pressing you for this sort of information? I feel like that's a rather specific thing.
I know. Well, Bacon asked Bruce that question. So, and I think it came up, and I'm not sure how. I think it might have been in our list of questions. Maybe because Bruce is a tech guy.
Yeah, man. Mm.
Evidently, when there's major furry conventions, the tech community kind of has a panic attack because there's no one at work. I heard recently, and I about died laughing just knowing some of the people I know that are furries, and they're people that I generally don't like.
Well, I know several that are in tech. I don't know if I would say that like I've ever experienced an abandoned office before during one of those cons, but I know that some of the hacker conventions, there's quite the showing. So, yeah.
Yeah, and never mind. I don't want to get onto that, even though Pride Month is getting close. Never mind.
Oh, okay.
I to each their own. I'm trying not to yuck anybody's yum, but there are definitely certain segments of
aren't you though? Because
this community where I scratch my head a little bit and go, I don't get it. I just don't.
Yeah, but you're kind of in a bitch mode tonight, so kind of thinking you are kind of trying to yuck some yum.
Maybe, but I am
Maybe.
spicy. I am spicy, and it may come out the wrong way. But I digress. So
yeah, it's fine.
Marmots. Oh my goodness, we need to have some education time. Marmots are absolutely adorable creatures. Let me see here. Can I get a picture? They look sort of like beavers without the big flat tails. They're cute and furry and squishy. Google marmots. MARMOT. Just do a Google. Otherwise, I have to spend too much time on Google just getting pictures, and they're cute. They tend to live in rocks.
Yeah, we'll totally lose Echoes at that point.
Yeah. It's bad enough. There's enough to cover. I don't need a side quest tonight. I just don't.
It sounds like we've got plenty of side quests lined up based on what little things you've teased.
Yes, through all of the DVRO stuff, so we can talk about the Medium blog, and if you dare, anything with Douche Canoe. But I don't know if I can handle him right now.
Well, whatever I need to put into the robot churn machine called Claude or whatever, I can certainly make it suffer for our audience's sake, because they're amazing, and we need to make sure that they are properly entertained and informed.
Yes. And to that end, I'm probably going to read the archived version of the Medium article verbatim because it's important and it pertains to this case. If you wish to do some ginger bites in the Claude A, I won't stop you.
Well, let me see what I can toss together, and I mean, maybe I need to send AIs after that Medium blog as well, because
I had to update the archive again for the Douche Canoe Esquire Law Office blog because it was a couple days behind already. It's like, good God, no one paying attention to this? Now that Bruce has derailed this stream with the fur topic, his work is done. Bruce, if it wasn't you, it would have been Mr. Jeep.
It's you and those damn antlers. I hear those tingle from time to time, and that's when you get crazy Arizona lawyers after you.
Yeah, well, Bruce covered his own fire. I thought for sure after Bruce got fired at by David Gingras, and then David started firing at me at Twitter, I thought, oh, surely I'm finally going to get my own blog article now. No, hasn't happened yet.
Nope.
Oh, well.
Yeah. Got it. Try harder.
So maybe I'll just remain uninteresting. I mean, no one else seems to give me much attention. Maybe I shouldn't complain. Oh,
yeah, but you're so good at it.
I just slip under everybody's radar. I don't know how I do it.
Look, given what Rob is going through and what everybody else has been going through, don't be sad about that.
No, Rob's got a $30,000 invoice to pay. So I didn't add Rob to the string, just like I didn't add Greg Gillespie. That'll be for another time, folks. I only had so much time while I was listening to Bruce read Twitter things. I was in a rush. Oh, God. Okay, where did I stop? Okay. October 10. This is D. Pretrial motions resolved, trial confirmed. On October 10, 25, the court resolved all pretrial motions and confirmed trial for October 21 and 22 of 2025. I know where I was on those days. The court denied David Gingras' motion to intervene. Intervention requires direct and immediate interest in the litigation. This matter is from a witness to the litigation and is ancillary. Denied respondent's motion to disqualify Gingras without prejudice as premature, and ruled the motion to strike and sanctions moot. The court further noted that on petitioner's representation of defective service, respondent withdrew the Code of Civil Procedure Section 473 motion. The withdrawal was a strategic election to preserve the trial dates and avoid bifurcating the proceeding. The motion had been fully prepped, briefed, and supported by exhibits and remained substantively viable. Life-threatening travel representation. On October 21, 2025, petitioner appeared by Zoom only and represented to the court that travel to San Francisco for trial would be, quote, life-threatening. The court admonished the petitioner that she had been previously ordered to appear in person and stated her motion was improper and not before the court today because someone was at a horse show. And did not file a request to leave Arizona as is required. She was never intending to show up the first week because she was busy at the West Scottsdale Classic or whatever the hell they call that thing, the Scottsdale Horse Show, West something Classic 2 or the horse stuff just fuddles me. Because no court reporter was available, the court continued the matter on October 22nd of the same year, with both parties ordered to appear in person. The court stated, this court will not extend or continue a request to renew restraining order with an indefinite period. That's what you wanted, I think. Petitioner's October 21 email to the court invoking a, quote, life-threatening risk representation, supported by letters from a nurse practitioner styling herself Dr. Colleen Green, DNP, which is not a thing, by the way. There's no such thing as a doctor who's a nurse. There's a reason there's distinctions. Yes, you can have a PhD of sorts in nursing, but you cannot, in any legitimate legal medical practice, refer to yourself as a doctor. It is misrepresentation of your not only of your education, but of course, like with doctors, you have to have boards and residencies and other licensing requirements. You have to spend the time if you want to be called Dr. anything in the medical profession. And I can speak to that because I know lots of people in it. I better not say any more about that. Let's see. And from a Dr. Amir Nassef. Okay, Exhibit 14. October 22, in-camera continuance to November 5. On October 22nd, the court held an in-camera hearing on petitioner's accommodation request. The court noted, the court's quote, the court notes that request is improper and untimely. Example 2 many minutes. The court nonetheless exercised its discretion to grant a brief continuance to November 5th, 2025, and ordered petitioner to be in San Francisco and to be in the courthouse in person for the trial. I'll just going through. I'm not going to read all the headings because they're there. Petitioner was registered as entry number 570. Oh, hey, it's listed here. In the 2025 Scottsdale Fall Classic 2, a USEF National A-rated hunter jumper competition held October 22 through 26, 25 at West World of Scottsdale, Arizona. I presume that's the horse rink, West World. With an entry closing date of October 6, 25. The full factual record of petitioner's competition activity, including her placements and the contemporaneous eyewitness observations of Kristen Harden, is set out at section 3B5 below. We'll get to that. We'll also read Laura's reaction to this filing, which is in her Medium blog, and some people already are theorizing if her current attorney might be on the way out too. We'll see. On November 5th, petitioner did not appear. Respondent appeared in person with counsel Omar Serrato and associated counsel Rachel Juarez. of the Emmy award-winning show Hot Bench. The court ruled because of the non-appearance of petitioner. Petitioner's request to renew restraining order is dismissed. The temporary restraining order against respondent is dissolved. No written order was prepared. Petitioner's post-dismissal procedural conduct is set out in detail, section 3 below. The factual sequence includes filings in this court, the California Court of Appeal, the U.S. Bankruptcy Court for the District of Arizona, and the Maricopa County Superior Court. On May 1, 2025, a Maricopa County grand jury indicted petitioner 7 felony counts, including fraudulent schemes, 4 counts of perjury, forgery, tampering, physical evidence arising from her conduct, Owens v. Eckerd. On November, we'll read through this fast because we know this. Number 4, Maricopa County grand jury returned a second indictment, adding 6. Actually, that should be 7 because it's total of 14. Additional felony counts arising from similar conduct against another victim, that being Greg Gillespie. Prior to her meeting Mr. Eckerd, the original charges were dismissed without prejudice and brought again in consolidation with the November 4, 2025 indictment plus 1 additional charge relating to Eckerd. The consolidated case number is there. On December 8, 2025, 33 days after the dismissal of her new renewal petition, petitioner Laura Owens filed a Chapter 7 voluntary petition, God, all these words, in the U.S. Bankruptcy Court for the District of Arizona with that case number. On the same date, petitioner signed under penalty of perjury on application to have the Chapter 7 filing fee waived, declaring, damn it.
Oh, get your voice.
You have no income and ability to pay the filing fee. I am fully dependent on family for basic living expenses and cannot afford to make payments now or within 120 days.
End quote. The Honorable Brenda K. Martin granted the fee waiver on December 27, 25. On January 9, 26, were you going to say something?
No.
I'm just scrolling through all this.
Yeah, go for it. I'm plucking apart the Jen Grass's law blog, and I had to do the Tor thing, because reasons, and I just want to make sure that I'm getting the right prompt here so I can adequately roast it.
So you're using up some kilowatts, burning some GPU cycles, or no? Well, it could be GPUs doing some co-processing. I don't know.
Well, yes, the AIs love they're very hungry for GPUs, and we feed them with fresh water and unicorn dust with the most rare of whales that we poach and try to destroy the ecosystem over. It's fine.
Oh. Okay. Let's see. Now I'm seeing that there's private chat comments. Are you still having problems? It shouldn't, because you're not in that slot.
Yeah, I just I think I hear it like maybe feedbacking a little bit on your end, but I don't know. We'll just
I don't know.
keep on going here.
I think it's not like painfully obvious.
At
least
it's pretty subtle.
Muted for 7 minutes, like the boomer I can be sometimes.
Well,
it's the first time I've done that. It's like, Christ, how did I go through a whole thing muted? No, that was a StreamYard problem.
That was pretty funny actually. But yes, that was a StreamYard problem.
Nothing was muted in my physical world here because I have things that flash and light up at me when I'm muted. No, yeah, it was StreamYard. Yeah, everyone's having StreamYard problems all the time. Okay, let's see. On January 26, Clayton filed an adversary complaint for the non-dischargeability of debt against the petitioner, pleading 2 counts of the nearly $200,000 in fee judgments under 11 U.S.C. for willful and malicious injury and ineligibility for discharge under 11 U.S.C. and for asset transfer, concealment, destruction, or falsification of financial records, knowing and fraudulent false claims, and unexplained loss of assets. Ooh, that's a lot. They were claiming fraud right there, essentially. Reductively. On February 12th, I know. See, I didn't quite realize there were quite so many words with that, but there we are. I didn't read, I don't know if they were available. I didn't read the adversary complaint specifically. I might have, maybe I skimmed. I can't remember now. There's too many documents. That's the problem with this stuff. Every day there's a whole another pile of shit to read through. It's just like, oh, God, spare me. Oh, let's see. On February 12, 26, Queen Jennifer, the United States trustee, filed an application for examination large proposal seeking 3 years of tax returns. I think it was DOJ Jennifer. I'm not sure. Maybe not.
Either.
Looking for tax returns, financial account statements, asset sale records, insurance, loan, storage, trust, and cherry tech debt records, identifying by name accounts held by Quartet Farms, Liz Max, Keybacker, Stylet, etc., 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 etc. All the holdings of alleged businesses from Boss Babe Bitch Laura Owens. On February 23 of 26, the bankruptcy court, Honorable Brenda K. Martin, signed an order extending the U.S. trustee's deadline to file an adversary complaint under 11 U.S.C. To deny discharge. On 15 of 26, that being April, before the Rule 2004 examination occurred and before the U.S. trustee filed its Section 727 complaint, petitioner stipulated, what's a 727 complaint? Okay, this has to be a 727 complaint. I don't know what that is. 727 complaint is a legal action filed in bankruptcy court by a creditor, trustee, or U.S. trustee to object to the debtor's right to a discharge in a Chapter 7 case. I'm just reading the Copilot AI, so take it for the grain of salt. It may or may not be.
May hallucinate or not.
The debtor remains personally liable for all disputed debts, purpose and timing, challenge the debt. Okay, we just get into some other stuff. Grounds for objection. Okay, let's see. The common grounds, 727 complaint can be filed if the debtor has committed acts that make them ineligible, include fraud or intentional misconduct, failure to preserve records, false statements or perjury, failure to explain asset losses, violating court orders, prior discharge within 8 years, and insider misconduct. Okay, that's enough of that side quest. I wasn't even going to bring it up. See, what? How's chat doing? I am just, like I said, I am steamrolling too. I'm not paying much attention to chat. Sorry, chat. I'm sorry. There's just a boatload, and I'm spicy. Damn it to hell, I'm spicy.
And he still refuses to drink.
I know. Well, every time I think life is going to get worse, then it's going to start, but it just doesn't happen. I don't know why. No, I don't want to end up on the side of the road with body cam footage. That's why.
No, that's why you call a friend.
Oh, that's what Uber is for.
Correct.
Getting sleepy, everybody. Just so you know. Chocolate. Yeah, I'm out of chocolate. Well, at least hard chocolate.
I still have some of the liquid chocolate.
I do, and I started inhaling the first one. I said, "Stop it! Slow down." So I'm rationing the second one. Yeah. Just in case you don't know, folks, this is the kind of pal and buddy Jeep Daddy is. He showed up almost unannounced at the cubbyhole, and he brought me some liquid chocolate in dairy form. I don't know if it was a bribe. I was waiting for the bribe request to follow that, but it hasn't happened yet. But I'm sure he will reserve his right and will file a continuance for such bribery petitions.
See, there's no statute of limitations on this sort of thing, so it could very well be just banked as a favor and waiting. It could be an Apple Pay request or a Venmo request at some point for the cost of that. I don't know. I haven't decided yet. So,
well, as soon as YouTube pays me, I will pay you. How about that?
I will send you my invoice.
How about that? For our first go, we've made a couple bucks, to which I'm grateful to our very generous chat.
Yes.
But again, we're not. What am I going to say? Damn, I hate that.
Look, the only thing we're shilling for tonight is your likes and your subs.
There and down there. So shill for likes, subs, and hypes. Don't forget the hypes. But otherwise, send your shekels, your pennies, your Canadian pesos, your Canuckistanian loonies, whatever you want to call them. All the above. Even euros and pounds and God, see, this is how bad I am.
Well, there's crowns in the Czech Republic.
Send them to Mike. He's got to pay. Yeah. It's going to get ugly, folks. He's got to hire an appeal attorney now, and that's not Omar. Omar doesn't do appellate work. It's a lot of money. It's going to be 5 figures and then some to fight this bullshit. Okay, let's digress further. Let's see. Okay, blah, 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 blah. Can't obtain a discharge. Okay, we'll skip ahead. Family code provides that we'll skip a lot. Shall issue an order for payment of attorney fees and cost prevailing petitioner, blah, 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 blah. Let's see if the respondent establishes by preponderance of evidence that the petitioner's request is frivolous or solely intended to abuse, intimidate, or cause unnecessary delay. Subsection C requires the court first to determine code, blah, 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 blah. The amended statute became operative 2023. Okay. Oh, now we got some case law, retroactively case law. Dragonis versus Calkins. Amended statute governs the motion. Frivolous standard. California is so wordy. Two-pronged subdivision are disjunctive. Fee award may issue on either frivolousness or improper purpose. California, blah, 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 blah. Sorry, I want the juicy parts right now.
All the blahs.
Lodestar method governs reasonableness. Withdrawal motion hours are compensable. Attorney hours devoted. Actually, we have a whole breakdown of Omar's hours, and I won't tell you how many pages it is. My God.
Oh my.
Yeah, we'll skim through it real fast just for throwing this. Fees incurred notwithstanding charitable funding. Oh, let's see. Let's talk about this because this mentions the GoFundMe. Under California law, fees are incurred for fee-shifting purposes even where a party is not personally out of pocket. A public crowdfunding campaign is squarely within the Lolly rule. Respondent's GoFundMe campaign is disclosed in candor to the court in the Serrata Declaration. Respondent remains contractually obligated on the fee balance. Any sums recovered will be applied first to the outstanding balance with the firm. There will be no duplicate recovery. So there you go. There's disclosure there.
Okay.
The bankruptcy filing does not bar this motion. Petitioner's Chapter 7 bankruptcy was dismissed with, well, not quite. He actually amended this. So this is not the amended filing. This is the one I have. He did some amending to this. It wasn't dismissed just yet. However, there's a stipulated motion signed between parties and DOJ Jennifer with Laura Owens and Mike Clayton. With U.S. trustee and Mr. Eckert, petitioner did not obtain a discharge and is barred from refiling for 1 year. Yes, that's the detail of the stipulation. Without a discharge, no Section 524 discharge injunction is issued. The automatic stay terminated on dismissal. Well, it will once it's officially ruled on by the court. So it's a minor procedural thing that's been cleared up. Pending appeal does not divest the court of jurisdiction over post-judgment fees motion, which is collateral matter under Civil Code of Procedure. California, blah, 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 blah. Motion is timely, no written order signed by the court, blah, 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 blah. Petitioner's conduct is worthy of Section 6344 fees. Let's see. Oh, my God. How many pages do we have? Oh, gosh, we're only halfway. Shitballs.
Oh, my.
Let's see. Maybe I just stick to some headlines. Objective frivolousness. Any reasonable attorney would agree the renewal petition was totally and completely without merit. I agree. This might be important. Family Section Code, Ritchie v. Conrad, DVRO renewal required petitioner to prove objectively reasonable apprehension of future abuse. Petitioner failed to do so because she did not get her ass there on time. Or ever. She didn't even get there. She didn't bother.
Oh, but I want to do the telegram. I want to dial in. Oh my God.
I'm dying. Help me. Oh, Your Honor, you need to give me an extension on death. I need a hospital bed strapped to the horse. I'm going to jump later today. Oh, and then I've got a supposed meeting. No, I've set up an appointment with what was it? Who was it? Was it a gastroenterologist? Supposedly. Who was it that read that? I think it was Buffy and Llama.
I kind of sort of remember that, and then like it was sort of nonsensical in the whole to do. Like there's no evidence or any sort of like records of like, oh yeah, well here's why I couldn't, and here like it was just like, trust me, brah, trust me. Like,
and there was specific language that suggested that she didn't actually go into an appointment. The most she did was maybe sit outside in a car to get GPS data, and claim that there's security footage of her being there.
yeah.
Like, why would you do that? Why would you try and use ancillary evidence of a medical appointment rather than the actual evidence of a real medical appointment?
I mean, probably out of the same brainchild that would not have real evidence of a pregnancy, maybe, like, and then like trying to like do something to sort of like, oh yeah, I can just Photoshop that or whatever.
I heard the words earlier today, and it strongly suggested that no one went into a building. We might have gone by the building, but we did not go into the building. I can't remember the words. I don't want to get them wrong. They're important because they were specific. So go watch Buffy and Llama, True Crime and Wine Time. They're hysterical, those two ladies. My God. I have to stifle my scuffles and my sniffles and my giggles. They're hysterical. Especially when Llama and Buffy get a little bit spicy themselves. Yeah. Go check out the ladies. I mean, and the three of them with bacon bears. That's hysterical. I'm telling you, we all just need to get in a room together and just whoop it up for a while.
That would be amazing.
It would be. We could knock Jubilee off their platform for about 7 hours if we had one of these televised. I promise you that. The ratings would be epic.
Yes, they would.
All the room, and because we all have big mouths. Every last one of us. That's the great thing. We all get that same room together. It's gonna fly. Oh,
I mean,
God.
normally I would say something like "Speak for yourself, bitch," but you're not wrong.
It would probably have to be rated R with the language and topic matter. Not X. I don't think it would be overtly explicit. Well, maybe it would be because it's a bunch of adults, but it would be intense. It would be intense. Let's see. Petitioners DV 700 left section blank. Okay, we covered that. I'm going to skip over it because I'm already bored of this thing. Sorry, Omar. I love you. I love you, Omar. I just can't read all this. But the bandwidth isn't here to read every last word. Recent violations recited in Petitioner's 2025 declaration do not arise from any direct interaction between parties. The center on Petitioner's own Arizona paternity case, Owens v. Eckerd, Mr. Marraccini's identification as a witness in that proceeding, his presence at the evidentiary hearing, where on Petitioner's own account, court security and sitting Arizona judge declined to exclude him. See, Petitioner declined the witness stand and cross-examination it required. This is talking about back in California. So let's see. Yes, she didn't show up. Let's see. Direct exam would have on that subject. What are we talking about? Let's see. Her direct exam would have anchored to the post-2020 conduct. Her declaration, conduct centered on her Arizona paternity case. Also, we talk a little bit about sort of potential defense. Let's see. Direct exam on the subject would have placed the petitioner's credibility squarely at issue and opened the door to impeachment material. I like impeachment material.
Ooh.
Marraccini had assembled and disclosed in trial preparation. That material included 2 purported Sutter Health My Chart messages Petitioner had produced as inbound providing correspondence. One dated from John Chung Kai Chan, MD, confirming stage 1A ovarian cancer being a very real cancer, not just something. I see. I'm telegraphing that document now. The thing that Laura fabricated, pretending to be doctors. And another dated from Rebecca Yee, confirming an oophorectomy and surgical abortion, both identified as forgeries by forensic examination. Forensic report reference only. Ooh, interesting. It also included contemporaneous equestrian competition records establishing Petitioner's active participation in show jumping during the very period she has represented as one of continuing trauma, including her champion finish at the Scottsdale Fall Classic 2 within days of her, quote, life-threatening representation to this court. We'll read the Hardin declaration in a moment. The petitioner had docket notice of the forgery exhibit from Mr. Marraccini's response over 2 months before the trial she had set. She did not appear at the hearing she herself had set. Isn't that something? Federal state court records independently confirm the pattern. See, we talk about Owens v. Eckerd. We talk about the judgment for Eckerd. Arizona Supreme Court denied review, awarded additional for Supreme Court and appellate staff. Petitioner's fee judgment exposure $996,000. May 1st, Maricopa County Grand Jury indicted petitioner, some felony counts, blah, 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 blah. All right, let's see what else we have. Let's skip ahead. Subjective improper purpose. The October 2025 timeline proves the renewal was prosecuted to abuse, intimidate, and cause unnecessary delay. See, we talk about the Scottsdale Fall Classic and number 1. the confirmation of trial dates. And number 2, my life is threatened on October 21.
Mhm.
The court, okay, yes. October 22, the in-camera continuance. Same day, petitioner began competing. The court granted a brief accommodation continuance, finding this is October. Just to remind everybody, October was when she declared these dates. I need an ADA accommodation, and you have to give it to me, or I'm gonna. She went to Judge Gold. I want to say the presiding judge of the division, demanding ADA accommodation. I want to say is how that happened. That's what I remember. That may not be quite right. Maybe it was right to Judge Gold, but it sounded like Laura went above her head. The judge
For
presiding.
what? What does somebody remember what the accommodation is? And
Not
like
disclosed
this,
because it's ADA. So, it falls under almost like HIPAA stuff for disclosure.
oh well.
I would love
guess.
to know what that in-camera review was, but because it was improper, and the court has discretion, they gave it to her anyhow. Because her ass was at the goddamn horse show. I covered that. See, this is how well I lie below the radar. That very weekend, the second after Megan Fox covered, I was on the mic. Megan was first. I was still coming home from work that Sunday. Just as soon as Megan was done, I warmed up the machine and I covered the damn thing. I pulled the actual Instagram post of Laura Michelle Owens collecting her first place ribbon from that account. I have that image. I have it in my archive. I know it existed. I covered it. Damn it. Sour grapes. See, that's not impressive. Everyone that it wasn't just Megan covering it. I was like number 2 that covered the damn thing. So pissy. Okay. The court granted the brief continuance, finding the request improper and untimely, and ordered the petitioner to appear in San Francisco and to be in the courthouse in person for trial. Scottsdale Fall Classic 2 began on the same date. Okay, it's the October 2, 22 to 26. Petitioner competed and won. Okay, that's more horse stuff. Yep, like I just said. We had the social media of her winning the award posted by the hosting social media account, which within hours, I'm sure, because everyone was talking about it, and we had the images. Laura, I'm sure, yelled at them and said, take it down now. And they did. So they took down her being posted with pictures. I forget the name of the guy who was giving their award standing right next to her. They took it down pretty fast for obvious reasons, because her ass wasn't where it should have been. Damn bitch. See, November 5th, petitioner did not appear and continued date she herself obtained. On November 5th, petitioner failed to appear at the trial she had set, twice been ordered to attend in person, and successfully continued to the date based on her representation that travel was life-threatening. The court dismissed the renewal. Petitioner registered for an out-of-state athletic competition by no later than October 6, 15 days before 2021. She competed at that thing. She failed to appear and stated she obtained on a She failed to appear on the continued date she had obtained on a medical incapacity record. Maybe that was the accommodation.
Okay.
I mean, she was claiming, I'm dying. It's life-threatening. Petitioner's claim that travel to San Francisco was life-threatening is further contradicted by her established pattern of obtaining travel authorization through proper channels in other proceedings. The Maricopa County Superior Court granted petitioner's motion to modify conditions of release for travel to California on September 4 to 8, September 10 to 15, September 23 to 26, and granted a second travel modification motion on September 18 for travel to California, allegedly to see her sister. Petitioner was thus demonstrably capable of seeking and obtaining travel authorization in advance through proper channels when she chose to do so. Petitioner formally announced her intent to file a new DVRO. This gets juicy. Filed the notice of appeal on December 4th, the Chapter 7 voluntary bankruptcy on December 8th, papers in the appellate court on January 20, and an Arizona injunction against harassment against a third-party content creator, Hey Rob, on January 20. Judicial notice respected request under evidence code section blah, blah, blah. See, I figured out a thing for him. It's Hey Rob, hey.
There we go.
Not Hey Girl, hey. Hey Girl, hey. Hey Girl, hey. Hey Rob, hey.
Hi, girl. Hi. Oh.
On April
Okay.
23rd of this year, April 2026, petitioner filed an ex parte application for extension of time to file opening brief, which the First District Court of Appeal granted the same day. See, like Rachel Juarez said, they will just do that. The appellate court isn't in a big hurry. Rob says, hey, Echo, hey. There you go. But if I can just move my fingers faster and actually get to the buttons. The filing is a 12-page single-spaced document drafted and signed by petitioner, ostensibly. In pro per. I suspect someone helped her. But that's just my opinion. Evidently, David Gingras got really pissy when Rachel Juarez suggested that he was helping Laura with her filings. I believe he is too, because I see words and phrases that really sound like him.
Yeah, he's got a very distinct cadence, and then like the way that he cites things and goes through and all that. It's like, yeah, that's probably not LO. There's not enough vocal fry in the words in some of those filings.
True, and it's not enough Laura GPT flowery language either. And GPT has got a different flavor to it too. I mean, it's getting difficult with the GPTs they seem to use on occasion.
Well, it's probably because they're too poor. They can't actually afford to pay for the better models that don't sound like a complete dipshit. But maybe.
I was trying to use Grok the other day. It's like, oh, I'm not doing nothing unless you pay me like $1 a month, and that's for a month. And then it goes up to
that one.
Then it goes up to $30 a month. I'm like, what the F? What is this extortion?
Hi, don't you know who owns that fucking platform?
Is that Elon Musk?
Yes.
Of course. Okay, never mind. No more digressions. Let's see.
Echoes has hit his limit. And I have reached a defective glass, and so I'm going to go fix this right now.
If I hear a clink, then I'll know you've dropped it. Let's see. The application conclusion contains formal written notice of intent. Here we go. This is important, folks. This is important. The application's conclusion. This is the application for the extension for the appeal. At section 5678, contains a formal written notice of intent to initiate further DVPA litigation against respondent. Quote,
petitioner hereby advises this court and places respondent on formal and final notice, I'll just add that independent of the outcome of this application, she intends to seek a new domestic violence protective order arising from respondent's recent and ongoing conduct.
Maybe I should have read it differently. Maybe I should read it differently.
Petitioner hereby advises this court and places respondent Mike Marraccini on formal notice that independent of the outcome of this application, she intends to seek a new domestic violence restraining order arising from respondent's recent and ongoing conduct.
Hey, that's not bad. I need a Bacon Bears adjudication of my devil pregnancy faker voice. We need some analysis here, what it sounds like on the other end. Yeah. Petitioner has the ability to pay. Family Code Section 270 requires a determination that petitioner has, or is reasonably likely to have, the ability to pay. The record reflects the following. Respondent's ability to pay showing is necessarily circumstantial. Full financial discovery against petitioner has not been undertaken. The cost of doing so in a post-dismissal posture, or almost post-dismissal, would itself exceed the fee award sought, defeating the purpose of Section 6344. Wow, how much does it cost? Dear God, I don't think I want to know. Direct disclosure from petitioner is also not a reliable record. Petitioner has a document pattern of misrepresenting her financial position when it serves her interests, including her sworn declaration of, quote,
no income and no ability to pay.
The $338 Chapter 7 filing fee on December 8th. A representation contradicted by her contemporaneous discretionary expenditure on USEF National A-rated equestrian competition 6 weeks earlier. Yes, call it out. Call it out, Omar. Call out
Do it.
spending on horse events. Do it. The court should therefore assess petitioner's ability to pay by reference to what petitioner has actually been observed to do with resources, what assets she has been federally alleged to control, and the demonstrated capacity to acquire and deploy resources across multiple simultaneous proceedings. The record on those metrics is substantial. Ducky says, my favorite co-pilot denial is Laura drinking energy drink while pregnant because that is dangerous activity. Ducky, Bruce, don't make me move your tech van to Hoboken. Oh no. Okay, there's something happening in chat. What's going on, you guys?
Uh-oh, what's going on? What happened while I was refilling my drinks?
There's some stuff happening in chat. They're having
Oh dear.
Yeah.
Here I am trying to burn down a rainforest to get some analysis over all this bullshit.
That happens.
It does.
Petitioners October 22 to 26 partition. Blah, blah, blah. More horse stuff. Horse stuff.
Horse shit? What? Horse shit? Is that what I heard? It sounds like a pile of horse shit.
A tier carries entry, stall, hauling, training, and lodging fees, supported by ongoing horse board, veterinary, farrier, insurance, and transportation expenses for the horse Sirocco 91, owned by petitioner Laura Owens, because we saw the video.
Oh my
And
God.
right in Sirocco 91. And they played some cheesy sort of music over those crappy speakers. Petitioners December 8 volunteer petition checked. No, it's schedule AB. No, let's see. We talked about some business entities. I'm skimming. The bankruptcy case will most likely be dismissed eventually once they get around to the formal dismissal. We'll skip through some of the dismissal stuff. December 8, petitioner swore under penalty of perjury that she currently has no income and no ability to pay the filing fee and was, quote, fully dependent on family for basic living expenses. Let's see. The same sworn application disclosed average monthly expenses of $4,077.63 and recurring family contributions of $27.50 per month. Eckerd's adversary complaint expressly contrasts that representation with petitioner's, quote, previous statements made under oath, end quote. Petitioner has retained private criminal defense counsel in the state of Arizona v. Owens. Josh Colesrud of law entered notice of appearance, and he is gone. Represented petitioner private paid basis until his motion to withdraw November 17 of 25. Petitioner's July, blah, blah, blah. I'm skimming more. Christian Luders of Guardian Law, private Phoenix defense firm, has appeared as petitioner's counsel of record by notice of stipulated substitution of defense counsel, filed March 3rd, and remains counsel of record to date. Judicial notice respectfully requested under evidence, blah, blah, blah. Okay. Petitioner has continuously prosecuted and defended litigation across the San Francisco Superior Court, California Court of Appeal, Maricopa County Superior Court, Family, Civil Harassment, and Bankruptcy Court simultaneously. Yeah, we don't know how. Imagine the little hamsters running on all those little wheels and all the squeaking therefrom.
Oh my God.
Fees accumulated from respondents' retention of Omar Serrato, the Eagle Law Firm. On or about July 9 through the date of the filing, respondent has incurred merit attorney fees of $90,100. Fees on fees of $58.50. Paralegal fees $98.25. $1,500 per hour. Let's see. Documented costs $38.58.98 and consist of cost of $63.71. Legal filing fees, printing, postage, blah blah blah. Court filing fees. You know, it's ridiculous how expensive it is just to file a piece of paper with the court. It's just ridiculous. Let's see. Combs reporting. See court reporter stuff. Wheels of Justice invoice. Oh, there's a whole stuff. Heather Bestia for November 5. Total fees and documented costs sum to $109,633.98. I'm exhausted already. Is there a cigarette? Fees sought in this motion.
Now, you're only supposed to do that after a good evening of getting fucked, not getting fucked of all this nonsense here in your face.
Yeah, well, That was enough of an annoyance. Fees sought in this motion reflects substantial voluntary downward adjustments before submission. Substantial amount of additional work was performed but not billed, including independently occurred. This is what I wanted to know. Independent occurred fees of the amazing Rachel E. Juarez of Birch and Juarez LLP, which are not reflected in this firm's billing and are not being requested as part. She can't be cheap either. I mean, she's got an Emmy, for Christ's sake. Her hourly's probably a lot. And she's worth it. She's brilliant. Let's see. Council incurred travel, lodging expenses not reflected in the cost and are not being requested, notwithstanding their potential recovery under family code. Conclusion. Oh, God, we're near the bottom. Respondent respectfully requests the court enter proposed order filed concurrently, blah, 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 bunch of stuff, and then it's signed and dated by Omar. Woohoo! Okay, that's the bottom of that one.
Wow.
All right, next part. Would you like to do some reading?
No.
I need to, but will you? I'll use the Mormon. Will you do some reading?
I hate you.
Typing to AI.
I'm still working on getting this thing structured so that it can actually go and suffer for us with not just Chingris's bullshit, but also Laura's.
Are you arguing with it? Is there an argument?
I wouldn't say arguing. I say that I'm like I told IV in chat. I'm structuring it so that it's at premium snark and not letting this level of bullshit infect it. Like, because I don't want to become a security incident for any chat bot out there, whether it's OpenAI or Anthropic or the others, except for maybe Grok, because Grok can die in a fire.
Bruce, the cheese curd eating moose, was using some AI that gave nothing but snarky responses to some of his to being targeted by douche. Did you see that?
Heard that. I did, Bruce. I was listening covertly on that, and the Monday bot. Oh my god. Okay, so I think I need a private message or something. I don't know. We got to figure out. I need to figure out how this thing works.
You two need to have a conversation.
Yeah, because I'm training Claude to be a prick like me, but apparently this one's already pre-programmed, and so maybe they can learn a thing or two from each other.
Should Bruce not object, I do have his email. And then I can share that for you two to engage in computer nerdery that goes above my pay grade.
Yeah, but you get to benefit from thanks to me.
Yeah. Well, of course. We all get to benefit from computer nerdery. Otherwise, none of this would exist right now. We would not be in auditory and visual form without computer nerdery. That's just facts of life.
Yes.
But if he's still here, he may have conked out already. He may have had too much wine time or something else. You know, he's a couple clicks over in the time zone. So,
yeah, that's true. Got to respect that.
And
I do respect those who stay up, like IB, who stays up way past their bedtime to come hang with us and
I know
all that. So,
duly
noted and appreciated.
Mutual love and respect and admiration here.
Mm-hmm.
Okay, if you're still busy, I'll keep going, but I'm gonna have to inhale more water.
I need a little bit more time to get where this needs to get, and then I will save you from doing I'll do my best via these hallucinations to save you from the Medium blogs and also from the Gin Grass blogs.
I'll spare you the first couple hundred pages. Okay. This one's 214. We won't look at all of it.
Couple hundred? Oh my god!
This particular document. That's the index motion of exhibits, motion for attorney's fees and costs. So it's got a lot of tables. I'm not going to read it. This is mostly Omar's work for filing. See, this is why lawyering costs so much. I mean, this thing's 214 pages. There's email threads. We've got the list. We've got the table of exhibits and things in the first part. So I'm going to skim through a lot of this very quickly. Exhibit 1's a billing statement, and let's see, there's the billing statement from Omar. See, I mean, I love the disclosure of all this. It's we've got every entry, it's dated, the person assigned to the task, and the cost is there. If you want it, go to Victims of Laura Owens, folks. Did I put that in the show notes today? I think I did. I usually do. Yes, it's in the show notes. It's, I think, the second one. So you can
Okay.
look at all the documents. That's why I include them. So, don't take my word for it, folks. Form your own conclusion. Go look at the documents for yourself. You can review Omar's work and all the things. And, some people that have axes to grind against Omar, which is not me. There are others that do, can be snarky and say, why are you charging so much money for this, that, and the other? Well, no. This is what they do, and this is why it takes so much, folks. I mean, look at this. There's hours here, and depending on the hourly rate, that's what it costs. Very few entries are less than $1,000. So that's facts of life with lawyers.
And I mean, to be fair to that cost, it's like I can believe it because like you have to pay extra attention because this shit has real world impact, right? So like, if you fuck something up here and like somebody goes to jail or somebody doesn't, or an innocent person ends up on death row or whatever, and it's like that's not okay. So like, it takes some time to go through this stuff and just not you can't hallucinate it like a fucking AI. So yeah. Like this is a skill.
Well, the first 30 or thereabout pages is just his breakdown of his fees and expenses. Exhibit 2, mini minutes, October 10, 21, 22, Carolyn Gold. Oh, this is interesting. Let's see. So we have all the mini minutes for the hearings that happened, including who was working the court that day. And these include motions for interviews, sanctions, disciplinary referral to state bar, moving party, David Gingras, butthead. Yes, he was trying to get Omar into trouble just by waltzing in the door as only he can. Remote appearances. Okay, we don't need to read all of this stuff because it's just procedural stuff, quite frankly. And you can read it for yourself. So, do sideways paper, mini minutes for October 21. I don't like sideways paper. We'll skip it. Let's see. Oh, maybe not. Remote appearances. Petitioner presented.
Just turn your computer up, sideways. It's fine.
Do I have a rotation thing? See, does it work?
Probably.
Hey, it worked. See,
there you go.
I'm not Judge Judy, and even I can turn something on my computer. Look at that. Look at that, folks. I wasn't sure if it was going to work. Let's see. Petitioner presented by video on Zoom. Improper. Raul, President. So Omar and President. Blah, blah, blah. Petitioner is on the calendar. Court notified parties that there's no court reporter available. Court admonished petitioner that she was previously ordered to be present in person. So she was already violating court orders, not showing up the first go around. Petitioner stated, and this is important, that she had filed an expedited motion for continuance and stated,
it would be threatening for my life to consider travel.
The court notes that her motion is improper, not before the court. See, we've read this a couple times. Maybe I should skip. Continue to the next day. This one's turned the other way. Oh, I love it. Let's see. Testing my button pushing abilities. Mini minutes for October 22. Let's see. The court. Let's see. Before the trial, the court held an in-camera hearing regarding petitioner's request for accommodation. The court acknowledged receipt of email 10/21/25 regarding petitioner's request. The court notes that the request is improper and untimely. However, the court exercised the discretion to hear the request in camera, not reported, and other party and public were excluded. God, I would love to know exactly what was said. After hearing the court allowed respondent counsel in the courtroom, and this part of the proceeding was reported. Having reviewed and considered petitioner's statement and request, based on reasonable accommodation request, the court granted the brief continuance. And then they showed up in November. Mini minutes for November 5th. Court appointed Heather Bastia as the shorthand reporter. A renewed restraining order. Public observers and media are allowed inside the courtroom. All witnesses are directed to remain outside. Petitioner is not present. Respondent is present. Attorney and, Rachel Juarez, associate counsel, are both present. Because of non-appearance of petitioner, that being Laura Owens, the request to renew restraining order is dismissed. The temporary restraining order was dissolved. There we go. And then Omar made oral request for fees and costs. Okay? Exhibit 3. Let's see what else we got here. Forensic. Oh, this was John Berryhill, a forensic report. Okay, we know about that. So for Maricopa County, jury grand indictment. Ooh, yeah, I think we've read this. This is 6. Count 7. Maybe count 1, 2, 3, 4. These are the criminal things. We know about that stuff. Horseshowing.com show approvals page. Ooh. Oh, look, here's some horse evidence. Here's some horse evidence.
Horse evidence. Let's go.
Let's see. I'm just skimming through. Okay, that's where she was. Was her name there? I didn't see her name. Hunter Jumper Association. Okay. Moving along. Information screenshot confirming jumper rating 2 closing date. Okay, this is just entry stuff. Oh, look, here's a black and white version of the Instagram. That's the same one.
Oh my God, it's not in color. That's great.
I have one in color though, and it was the CEP shows. This is the same exact picture. This was on Instagram.
Goddamn.
Congratulations to the winners of the Outreach CEP Hunter Derbies. Look, Laura Owens and Sirocco 91.
Oh.
Yeah, that was on that day. Mm-hmm. She was there. Photo
near death. She was there on the brink of ultimate destruction.
More black and white. We like the black and white. It's very timeless. Here she is, number 570, riding Sirocco 91. Oh, can we make that a little bit smaller? D-Biggin. There she is. There she is. That's her. Yep. Didn't realize the elevation was a little bit above grade there. Interesting. Oh, rotate again. Rotation. Gosh, it's bad. Embiggen in rotation. Notice of appeal. Let's see, from Laura Owens. This was her appeal filing. Designation of record on appeal. Ooh. Here we go. Let's see. Is there anything in here? Declaration, reporter's transcript. What is that? Documents received by court. Okay. Okay, that's just her stuff for appeal stuff. Civil case information statement. This is the boring stuff. Sorry, folks. Let's see. Oh, mini minutes for November 5th. Okay, we know about that. BEMKey reporting video services. Court reporter cancellation fee for October 22. That's terrible. See? She just likes to cost people money.
Yep. Or try to get some herself by ways of inappropriate things. But
Combs reporting for the November 5th. Wow, is that two? Oh my God, that was $2,000, and they didn't even have a trial. Holy hell! Here we go. This was one of the things I wanted to read. Declaration of Kristen Harden, October 30th, 2025. Eyewitness declaration of professional equestrian observing petitioner Laura Owens at Westworld of Scottsdale on October 21, 22, 24, 25, and 26, according to that. Oh, here's the paperwork. Declaration in support of respondent. I, Kristen Harden, declared. Well, we'll declarate too. Why not?
I do declare.
Oh. I declare. I say, I do declare. Sometimes I fall into a southern voice for jingers, but not tonight. Kristen Harden says she's over 18, submitting the declaration in support of respondent Mike Marraccini in the DVRO renewal case involving Laura Owens. I am a professional equestrian and the owner-operator of Kristen Harden's stables. I have been competing at the Grand Prix show jumping level for over 25 years. That's a little while.
Mm-hmm.
I operate a training facility in Portola Valley, California, and regularly attend equestrian competitions and events throughout the country, including Westworld of Scottsdale. I wonder, never mind. I won't say what I'm thinking. I should keep that one to myself.
Oh, holding out on us now, I see.
Yeah, well, we don't want to, never mind. I shouldn't say that either.
Tell me later. Tell me later.
I'm just thinking.
I'll bribe you with more chocolate milk.
Sure. Let's see. I was at Westworld of Scottsdale for the Fall Classic equestrian event. At approximately 3 p.m. Mountain Standard Time, I observed Ryan Miller, a horse trainer in the Phoenix area, riding a horse named Sirocco 91 in the covered jumper arena. Sirocco 91 is owned by Laura Michelle Owens. I noticed a thin female with a high ponytail and green top near Ryan during this time. Based on my observations the following day, I believe this was Laura Owens. Well, I think she's got the thin female with the obnoxious ponytail. I mean, high ponytail. Accurate. That seems accurate. On October 22, at approximately 11 a.m. Mountain Standard Time, I saw Laura Owens at the Westworld facility. I am certain this was Laura Owens, and I had a clear view of her face and body. Laura was watching Ryan show Sirocco 91. During this observation, Laura was wearing a green hoodie identical to the green hoodie on the woman I had seen the day before and black leggings. That sounds like her style. Her hair was pulled back in a ponytail, and she was wearing makeup. I observed Laura's demeanor and behavior during this time. She appeared happy and was smiling frequently. She did not appear to be in any distress or despair whatsoever. I found it noteworthy that Laura did not greet or speak to anyone other than her trainer, Ryan, which I thought was unusual behavior. Laura arrived in a black Hyundai Tucson with a pink license plate. I observed her going in and out of this vehicle multiple times, taking items to and from the car. Laura remained at Westworld for approximately 1 hour. While watching Ryan, I observed Laura on her phone. She was holding the phone down in front of her. On Friday, October 24, I observed Laura at Westworld accompanied by an individual I later recognized as her mother, Jan Black. A.k.a. Elizabeth Ann Naylor Owens, because that's her real name, not Jan Black. And I would love to get to the bottom of why we use a stage name. And no, I'm not convinced it's just because of the radio. Nope, I'm not. I observed Laura and Jan walking together to the black Hyundai Tucson with the pink license plate. Laura competed in several horse jumping events at the Scottsdale Fall Classic 2 equestrian competition at the Westworld facility between Friday, October 24, Sunday, October 26, 2025, including the USHJA Hunter or Low Children's Adult Hunter 2.6 and or the modified Child Adult Equestrian OF 2'9". Everything. It's so cumbersome, this horse language. Laura took several first-place titles between Friday, October 24, Sunday, October 26 at the Scottsdale Fall Classic 2 at the Westworld facility, including champion in the OR Low Children's Adult Hunter. At no time between Monday the 21st, Sunday the 26th, did I observe Laura looking fatigued, distressed, in despair, or experiencing any physical issues. On the contrary, she appeared happy, energetic, and smiling. And she declares under penalty of perjury, etc. Kristen Harden. But she was at death's door and then bleeding from unspeakable places. I'm just bleeding. I'm bleeding out. I was so near death, I had low, hemoglobin levels or whatever. I was close to transfusion level, I think is what she said, if I recall correctly. Tony Marie says, and this is interesting to me, I'm very curious if RM has had conversations with the SFDA. Oh, we would love to know if there have been any conversations with prosecutors in San Francisco or California. We would love to know. We would indeed. Okay, we'll skim past that. Let's see, Exhibit 12, Arizona travel authorizations. Yeah. We know some of this. We cover them as they happen. Let's see, the September stuff. We'll skip ahead. Reporter's transcript. Holding berries at sea. Richie V. Conrad, approach opera. What is this? Oh, what is this? What do we have here? We have something historic from 2020.
Ooh.
Richie V. Conrad, reasonable apprehension ruling. What is this about? Full holding of a can, the berries, a drink, holding up berries. Oh, Mike Marraccini. Oh my God. Okay, what is this? So that says that he was at Barry's. Oh, this is when they somehow ended up at Barry's at the same time in San Francisco. And she claimed it was him. He says he was somewhere else. He said he was in another town altogether. So this is a report of that. Let's see. Petitioner's life-threatening in quotes emailed to the court October 21. Ooh! Ooh! I like life-threatening. We're going to read this. Okay, I'm reading this in Laura Owens. Folks, brace yourself. Should I use demon voice or should I use the squeaky voice?
Oh, let's see. What's the I think this is demon voice worthy.
Okay, we'll use demon voice. If I could set up a poll in StreamYard, I'd do that really quick for chat, but just for expediency's sake.
Dear supervising family law judge and ADA coordinator.
Yes, this is the correct choice. Please continue.
I have a long cause hearing in my domestic violence restraining order matter blah blah blah, scheduled to begin tomorrow, October 22nd, 2025. At today's hearing, where I appeared on Zoom in Arizona, Judge Gold stated that if I did not appear in person tomorrow, my restraining order will be dismissed, even though the court's own October 10 mini minutes state that the court strongly suggests in-person appearance, which I understood to be advisory, not mandatory.
Are we doing okay with that? Is that all right?
I am having a hard time concentrating on setting up this project, listening to this because it's that fucking good. This is like, yes, this is it.
I get it through my cans too, so it throws me off slightly. I just have to ignore what I hear when I use it.
I have submitted medical documentation establishing that travel or in-person attendance poses a life-threatening risk.
I don't even.
Oh God.
Are you okay over there? Like, what's going on?
I'm choking on the bullshit.
Oh,
I know
okay.
I only had this. Someone else was sneezing bullshit. Oh Jesus.
It's allergic to bullshit. Yes.
Holy hell. Oh, pardon me, chat. While I compose myself.
Oh, Echoes is overcome.
I'm verklempt, damn it. I'm verklempt.
My expedited request for reconsideration of motion to continue, filed October 17, 2025, which is attached, included a letter from Dr. Colleen Green, stating that in-person attendance would be life-threatening for her. End quote. There is also an additional letter from Dr. Amir Nassif requesting that the court make accommodations for postponement of her required duties at this time. Additionally, on August 5, 2025, I filed a motion to proceed by declaration and waive live testimony, which I have attached, and which included an ADA accommodation request based on diagnosed autism spectrum disorder, post-traumatic distress disorder.
Oh, okay. Let's just abuse that term, just like miscarriage and blah, blah, blah. Okay. Shut the fuck up. Oh, that was the outside voice. Sorry. Please continue.
And related medical conditions. That motion has never been ruled upon because the court has said that non-appearance will result in a dismissal of the long-standing protective order originally stipulated to in 2018. I am seeking immediate guidance or relief under the Americans with Disabilities Act, 42 U.S.C. paragraph 12131 et SEQ? What? California Code, Government Code 11135, and California Rules of Court Rule 1.1. which require reasonable accommodations to ensure meaningful access to judicial proceedings. Opposing counsel and Judge Gold's department clerk have been copied on this message to ensure full transparency and compliance with ex parte communication rules. Thank you for your urgent attention to this matter.
Laura Owens. Oh my God.
That's good. That's right up there with like some of the other like truths that are posted out there by certain stained individuals. But, oh my God,
You
that's
know, and I'm
great.
actually
That's
shifting
fucking great.
a little further, speaking of truth bombs, because I've gone back and looked at some Instagram, the JFC official Instagram account stuff, and Bacon Bear talked about this for a good long while. There are some nasty things by the JFC official thing that I don't really pay attention to because I'm not watching the Twitter hardly at all. I kind of flip through it and just really quickly, is there anything interesting? Is there some document I haven't seen somewhere else? That's about all I use the JFC Instagrammer for. But when Bacon brought up that the JFC Instagrammer was kind of gatekeeping, supporting Mike in his GoFundMe by demanding that Mike prove to her or them, I think it's a her, I'm not totally sure the Instagrammer is a her, but proving to them that the money raised in the GoFundMe was being used for proper purposes. And that leads me to a new button I have of Bacon Bears. So for all of you still here, all 99 of you currently, here's the new button that I've clipped of Bacon. This is great.
Who the fuck are you? Because I need anybody to explain to me who it is that you think you are.
I love that. I might just have to.
That's nice.
Yeah. That was Bacon giving the JFC Instagrammer what for. And I would say rightfully so.
I mean, I love this. Like that stands out as itself, but like that first one of just like, who the fuck do you think you are? Like, yeah, who the fuck are you?
Yeah, I've actually got it set up so I don't have to play the whole thing. I can just trigger the first part.
Yeah.
Lovely.
That's that part right there in and of itself is fucking brilliant. And then the rest of it is like just icing on the cake.
Yes. I didn't tell Bacon I was going to clip her, but there it is. I couldn't help it. PCB Amy asks, what day was that stream on? It was a couple back, and I've watched so much Bacon lately, and she's been with other people. I've lost track of it. I won't waste the time go digging for that. But if you haven't followed Bacon Bears, you should do so. I highly recommend Bacon Bears because Bacon, oh Lord help us, she tells it the way it is, folks. She calls it as she sees it, and she pulls no punches. Yeah. LMP.
Yeah, I don't know what day, and I don't know what day it was on either, because I don't know if I was commuting or what, but I caught a bit of it and blew up the chat for a hot second, and then bounced.
Yeah, as you do. You come in like a ball and leave the dust for somebody else. No, that's
sometimes.
That's David Jingles.
Yeah, no, I'm nicer than that. Maybe don't let it get out.
Martine V says Jack Fox is going to go over this doc. I sure hope so. I miss Jack. I miss hearing him on this case. I mean, I love listening to everything else he does, but I miss him on this one specifically because all of the stuff I suspect and feel the tingle in my bones that there's bullshit here, he just affirms it for me later. So I know that my intuition is at least mostly calibrated. Yeah, so I kind of rely on Jack just for recalibration from time to time. Let's see, more documents. Let's see, the law. This is bankruptcy stuff. This is her filing for bankruptcy, everybody. We've seen this stuff because we've talked about bankruptcy.
Oh, yeah, the thrown out bankruptcy case that they're trying to claim wasn't actually thrown out or dismissed, but okay, yeah, all right. Mm-hmm.
Stipulated dismissal. I think the court just needs to get around to it, and any final stuff from the deal, or was that mom and dad's? Now I'm merging bankruptcies in my head because it hurts too much. Yeah, that should. I suspect that'll get finalized by the court eventually. So, despite David Gingras threatening to sue Omar for lying about Laura Owens' case, the bankruptcy case being, well, it's not going to be continued. It's done.
Yeah.
They gave her the way out. Stipulated motion for dismissal that everyone signed off on. She can't carry that out any further because guess what'll happen? It'll get worse for her. Yes, it will.
Oh, yes, it will.
You know, I mean, I suppose the bankruptcy judge could say, you know what? I'm interested in how things have moved around in weird and curious ways. Maybe I won't accept this motion to dismiss, and this is going to have to go to some kind of trial.
I mean, if DOJ Jennifer is as competent at her job as she put up in that audio recording that we listened to, I don't know. If I were the judge, I'd be like, say more. Say more.
What would happen if it were to go further? It would be the next thing that didn't happen was the 2004 examination, where she has to talk to DOJ Jennifer and give a deposition about all the things and inconsistencies and all the stuff that Queen Jennifer was asking, which was a lot. There was a lot, in my opinion, that looked like bankruptcy fraud to me, but that's just my opinion. All I know about
before you, because since I'm still sort of turning all of the boiling oceans and things, which one of the links in there is the Laura Owens in our show notes? Which one is the correct one for the Laura Owens Medium blog that I need to have ChatGPT or Claude go wreck?
I've got the. Oh, well, can it do archive or do you need the real one?
I prefer the real live one, but archive will work. Is it like a PDF of some kind or whatever?
No, I don't know what the archive is. But
give me the live one. Just ping it to me privately, and I'll look at the. I'll look for that.
Yeah, what the hell is private chat? There it is. I think it's moved again. Let's see. It should be this. Oh, but chat could type it faster than me. See if that one works.
Okay.
But we're not there yet. We're still skimming through this email.
I know, but I'm trying to just make sure that I'm ready when the time comes.
Well, I mean, 2/3 of the way, roughly, because this is all just.
I know. I'm running out of time to have the robots go do their thing.
I know. We're going to see if there's anything more interesting at the bottom. It's lots of numbers and bankruptcy stuff that I just don't care about. We'll leave the bankruptcy things to just Big Tiff Dog, as opposed to just Jen. We'll leave it to just Big Tiff Dog. Tiff is the money lady. She knows about these things. I can't pretend. I can sort of follow high-level stuff, but some of the other things, I'm like, how do you find where all these... How do you know these things? Where do you go looking for everybody they owe money to? That's amazing. It's amazeballs. Mailing list. Oh my God. Still more bankruptcy stuff. Oh, what's this? Ooh, Eileen Lashinsky. Ooh, Queen Jennifer. Ooh, U.S. trustee. Oh, application for 2004 examination request for production of documents. Oh, I think we already read that. I think we read this thing. We want Laura Michelle Owens to give us her shit. Request for production. Oh my God. Tax returns, financial statements, copies of checks, sales, insurance, loan applications, storage units, safe deposit, trust, Cherry Tech debt. They are really interested in that Cherry Tech stuff. My golly Moses. Oh, let's see. Notice of lodging proposed to order granting. Granting U.S. trustees application for request production of documents. This is all more bankruptcy stuff. Order granting states trustees unopposed motion to extend the line for filing section 727 objection. Okay. There's so many forms. Stipulated motion to dismiss with prejudice. We've read that in a previous episode. Go back through the videos, folks. We covered this one. Yes, we did. But it's good. Good stuff. The stipulated motion to dismiss. And everybody signed it. Yep. Laura Owens, Lashinsky, Marcus, etc. Adversary complaint. This is the complaint they filed against her from Eckerd. I think I covered this one too. This is like all old news. non-dischargeability, and so on and so forth. Application to have Chapter 7 filing fee waived. Sworn indigency. They need to re-review that, I think. The indigency status.
That would be good.
I don't think she's very indigent. But we're going to claim that to try and be proof.
Maybe.
I mean, that's
Maybe
why
they've got some money stuffed into the mattress somewhere.
Just file bankruptcy and it all goes away. Clayton can't do anything to you if you file for bankruptcy. Well, how did that one go, David? Woo!
Well, that's he's just a fucking moron. That's why that one went so well. But yeah, I don't know. Maybe they are hiding a bunch of money in a mattress somewhere.
Sister? That's been a theory.
It's inside the black chair. Echoes. It's inside the chair. The black chair. It's in that.
No thanks. Okay, press the red button. It all goes away, is what he said. We covered that too. We had the video to prove it. And it's it's almost my greatest hits. I think I'll send us out to the bankruptcy plot. I think that'll be our closing musical moment.
Oh, Christ. I crack myself up sometimes.
Requesting court date for motion for attorney's fees and costs. Okay, let's see. Purported Sutter Health My Chart messages. Oh, this is 2016. This is old stuff. Oh, which one is this? Oh, this is the cancer fraud stuff.
Oh.
Do I dare read it? Do we need a memory lane moment? Let's
maybe kill a little time for me, or not for me, but for Claude.
Is Claude still chomping at the bit?
It's churning away at the Laura Owens blog as we speak.
God, at the rate he's churning, I could have a couple pounds of butter. My God. I do like butter.
I just kicked it off a few minutes ago. I finally got it structured to where I can actually give it salient things to go look at. Oh my God, it's actually putting something out. Okay, whatever.
You need AI to structure the AI.
Basically, yes. That's why I'm pitting Claude and ChatGPT together for this entire month. I just want to see.
Grok, can you make an outline for Claude to formulate this link?
Yeah. All it's going to do is turn it into a white supremacist. That's all Grok's going to do because that's all it's good at.
I saw some Grok versus, what was the other one? Claude talking to each other. That was funny.
Nice.
I meant to send that one to you, but I forgot. It was just a short that popped up in my YouTube one day, and it was just a guy who was trying to get them to, I don't know, gaslight one or the other or something, and then I think it was Claude that says, "Oh, you're not as bad a person as I thought." It just didn't reach the conclusion the human wanted it to reach.
Mm-hmm.
It was funny. Okay. Number one. I'll do some reading here. Dear Laura. Do I need no, I won't do a voice. I mean, this is Laura, but
dear Laura. That's not her. That's the doctor.
No, this is the fake doctor. Dear Laura, thank you for your email. I'm so sorry. You are going through such a rough time right now, and will do my best to help you through it. God, sounds like a teenager. I read the messages you sent me from your boyfriend and answer his questions. See, we can't even get grammar and syntax correctly. A doctor will never send you advice about how to deal with your boyfriend. Jesus. Stage 1A is without a doubt considered to be true cancer and something that we take very seriously. You are correct, Laura, that this cancer is found only in one ovary. He is incorrect in his saying that this means you just might have malignant cancer cells. Please tell him that, yes, I have diagnosed you with real ovarian cancer, not something I am not sure what is meant by the message you forwarded that says I would only be diagnosing if it were something other than stage 1A. That is a very real stage and simply means that it has not spread beyond your right ovary. I recommend looking at the American Cancer Society's webpage for more information. A doctor would never do that. In addition, you can let him know that your diagnosis and treatment has been complicated by your pregnancy, which on its own has been extremely difficult and unusual. I would
Yeah.
strongly encourage him to change his attitude and support you at this time. I sincerely hope things get better.
I am done. Hey, Clay.
Damn it! I'm on the wrong page again. I wish I had that. I mean, I wish she somewhere said all the best and we could clip that. I wish I had it, but
I have done nothing except get pregnant by the fucking bachelor.
sure, lady, sure.
Hey, maybe we've got enough audio clips of her doing these weird rants that we can ask some like some audio-based AI thing to like manufacture something, for entertainment purposes only, of course.
I want the real thing. Call me a purist.
Yes, but you can echoes. You can want in one hand and shit in the other. And guess which one is going to fill up first?
Well, I'm right-handed, so
Oh, well,
don't think about it too hard. Never mind. Okay.
Pick your hand, I guess. Like if you want to get that specific about it.
The other fake medical record from a not real Rebecca Yee MD to Laura Owens. Like they send emails telling you things. I mean, that doesn't work.
They don't send you emails; they send you messages through my chart. But yeah, okay, let's go.
Make sure we have like certain banners and certain information, and we take the. I would like to know if my chart and Sutter Health were notified that their trademark copyrights, their intellectual properties, were being co-opted by Laura Owens, allegedly.
And here I thought you were about to say, I wonder if these are actually the way that the MyChart emails are actually formatted.
I'm pretty sure.
I was about to go look, but that's fine.
And it says, "Hi, Miss Owens. Yesterday you received ovary removal surgery." Yeah, because they're going to tell you yesterday you had ovary. Yesterday you had surgery. You might still be out of it, but just to remind you, in case you forgot, you had surgery. Fuck me. Of your right ovary as well as a surgical abortion. We were having a 2-for-1 deal. Hopefully you got the coupon. Due to your recent medical history, I will wait to confirm pregnancy termination until blood work and a follow-up ultrasound are completed, although there were no complications during the procedure. As you explained to me, you have already experienced emotional side effects such as extreme fatigue, depression, and mood swings. These are common, and I would ask your boyfriend to support you during recovery. Come on.
Really?
Really, really. That's the kind of shit she was selling Mike.
God.
Among other things. And her rather salacious filings accusing him of sexual abuse and weirdness.
Oh, Christ.
Yeah. I mean, there's a bunch of weird... Never mind. I can't say it. I could on Rumble.
Tell me later.
I can't say it here. I'll forget by then. Doesn't matter.
Probably.
I was just very frank and use very direct words. Petitioner appellant Laura Owens, ex parte. Let's see, what is this? It's extension for time filing opening brief. We've already read through this. This is just her wanting to get extra time, but there's no motion to compel lunch. Oh, I wonder if it's interesting. Have I read this? Now I can't remember. Maybe I skipped
her appeal to go get lunch?
No, that's David's appeal. Oh. No, David filed a motion for Woodnick in the Eckert case. Motion to compel lunch, which rambled on for I get how many dozen pages. Let's see. Petition file extension. Let's see. I'm just looking to see. Oh, I don't know. It goes on for a little ways. Oh, is this where she says it? Is this it? Yes. Okay. I need to read this one. Sorry.
Don't be sorry. Go do you?
Where she puts Mike on formal notice that she's not done abusing him yet. So I think I better read it first.
Okay, formal notice. Here we go.
This was in Omar's filing. Yes, Martine, this is page 203 of the 214 pages of the 504-2026 attorney fees and cost exhibits redacted filing. This is also in my show notes down below, so if you would like to follow along at home, I'm not sure which one of the 4 it is in the Volo links that I included, but it's the biggest one. So just find the one until you find the 214 pages. And again, this is page 203. Petitioner
Such a size queen. They're all big. Yeah, of course they are.
Can we handle more voice? Can we handle
Go
more
for
voice?
it. Do it.
Same request. Squeaky voice or devil voice?
Let's see.
Same request.
I have my vote, but I kind of want to hear from chat what y'all want to hear. Squeaky or Satan?
Yes. Do you want devil pregnancy faker or do you want squeaky faker? Which would you like, chat? Let me know.
Let's go. Come on. Let's go. Chat's in. Get your votes.
If chat's paying attention by the time the delay gets through. What do you want, chat? Squeaky?
We have 1 vote for squeaky.
All right.
1 vote for devil. Okay.
Devil. Right. Okay, they'll cancel out already.
Yep, so we're at 0. Oh, Jen says evil devil. Okay.
Couch Fairy. All right. Very good. See, I wish I could do quick polls. Come on, StreamYard. I want quick polls.
Okay, so PCB Amy says demon voice. Okay, squeaky. So we're +1 for devil, +2, +3 for devil. Okay.
Devil's winning.
I think devil's going to win this one. Devil +4.
Oh. All right. I think Succubus of Scottsdale wins.
I think devil wins this one. I was going to go with squeaky. So, but I'm still outvoted. So by all means, let's hear it.
Oh God. Okay. Now I gotta not overdo it.
Hey Satan! Hey Satan!
Oh my Lord. Cousin Alex gave one for squeaky. It's evening out a little more. Hello, bounce.
Okay. All right.
I can't mix the two. That would be hysterical.
That'd be. I don't know if my brain could handle that. I'd probably have to hang up.
I can't do both at the same time if I actually get on the right page. Can I? No.
Nope.
I can only
do one. We'll do a little of both. How about that?
Oh, there we go. All right. Artistic interpretations and flows.
It might get in the dramatic parts. Maybe I switch to Succubus of Scottsdale.
Do it. That's right. This is fuck around and find out Friday. Let's go.
This is what I said last stream. I need a knob so I can just sort of fade, crossfade.
Crank it down and then crank it back over. Yeah.
I just need a pitch control knob. I might have to buy more tech and have a vocal processor I can manipulate in real time.
Yeah, that's what you need is more shit in your little cubby hole there.
Try an experiment here. I shouldn't be doing this live. This is terrible.
Let's see, is that live?
It is live.
Now, if I do this, let's see.
Can we go from this one
down to that one?
Oh yeah,
it's true. Oh my God, this could.
Yeah, now you're kind of like medium alto voice there. That's interesting.
This is awkward, but maybe we should go.
Oh my God. Honey, this is your show. I'm just here to drink on stream, make snarky comments, and occasionally bring you bribery chocolate milk.
Oh no!
When you bitch about me drinking it on stream,
I agree, Jen. The couch fairy. Oh damn it! It moved again. I used to have a lava lamp. I used to ages ago. Back in the dark ages in Stonehenge when I was still an undergrad. I had the obligatory dorm lava lamp. It was sort of a reddy pink color. Yeah.
Okay, well, we gotta make sure that we're respectful of Ducky's request here, because
what does non-sexual voice mean? What? I don't know how to do that.
Laura thinks her voice is seductive all the time, so.
And Amy says, go to Amy's. I don't know how you think demon voice is sexual sounding, Ducky.
Again, I don't know about Echoes, because he's his judgy bitch. As we've demonstrated in previous lives where he clutches his pearls when he has no fucking business clutching his pearls.
Yeah.
But I do not judge. So if that devil voice is sexy to you, by all means, live your best life, honey, and I will support you. We're good.
We all need a little devil in us at certain times. Never mind. Okay.
Yeah, it's fine.
Let's-
Like I said, I'm not here to judge. So,
I'm not sure I can do the knob and hit all the buttons. You know what? Maybe this is dangerous. Okay, you know what? I'll just switch between the two. This is going to get too complicated.
you talked yourself off your own ledge. That's brilliant. What am I even doing here?
I can't even remember. Is that where it was? Somewhere around there.
Oh my god. Okay. Let me just get out of there. See, if they need to just do a software update where you can set that as a live action fader and you can just play with it.
Look, if I knew anybody that actually worked at that fucking company, I would totally suggest it, but I don't anymore. So
it wouldn't take much. I got all these knobs and things. Good lord.
Yeah.
And I've got an action knob, so it's giving me a feature.
Ah, yes, my action knobs. That's exactly what Jen was looking for. Oh, wait, never mind. Sorry.
You know, we all could use some action knobs, but never mind.
Never mind, indeed.
Petitioner appellant Laura Owens applies ex parte pursuant to California Rules of Court Rule 8.6 for a 60-day extension of time to file her opening briefs. Not bikinis, but opening brief. Currently due April 28, 2026 to and including June 27, 2026. Introduction. On November 5, petitioner's request to renew a DVRO was dismissed for non-appearance on a record that does not accurately reflect what I wanted to say that occurred that morning. Since that dismissal, petitioner has actively sought appellate representation. In the weeks immediately preceding this filing, two sources of legal counsel who had each conducted substantive reviews of this matter declined to represent her. Not because the appeal lacks merit, of course, but because the facts underlying it are not in the official record. Both stated they would reconsider once the deficiency is corrected. The 60 days petitioner requests are what is needed to correct that record, secure the representation these reviewers have confirmed this appeal warrants, and prepare a brief, again not bikinis, that accurately presents what this court is being asked to decide. The record deficiency is traceable to a specific and documented procedural problem. On December 3, 2025, petitioner filed a motion to correct and augment the record in the San Francisco Supreme Court. That motion was never contested and was never ruled upon. The following day, petitioner filed her notice of appeal, which under settled California law divested this trial court of jurisdiction over the pending motion. The motion has never been adjudicated in any court.
As a result, the facts underlying this appeal are not before this court. The official record, 5 pages documenting a 4-minute proceeding, reflects only that petitioner did not appear and the matter was dismissed. It contains no reference to the 2 written pre-hearing notifications petitioner sent to the court, advising of a life-threatening medical emergency. The court's written acknowledgement of those notifications received before the hearing began. The medical documentation she submitted, her offer of HIPAA authorization that no one accepted, the ADA accommodation requests she raised and which were denied, the ex parte communications between court staff and respondents' counsel from which she was entirely excluded the day before the hearing, or her formal written refusal to waive her statutory right to an official court reporter, a refusal that under the court's own written directive required the matter to be continued. That record cannot support meaningful appellate review. An opening brief, again, not bikini, filed on it the proceeding it purports to address. 60 days to correct the record, obtain counsel, and brief the actual issues represented in my chat GPT M dashes all throughout this thing, against a backdrop of active state bar proceedings against both of respondents' attorneys who appeared at the dismissal hearing, and new conduct by respondent requiring legal investigation, is not a delay. It is the minimum necessary to proceed responsibly.
Who's she fooling? Who's she fooling?
Who the fuck are you?
I've got to move these around so some of these sounds are a little more accessible. 5 full pages of stuff, my God. Okay, let's see, where was I?
The record versus what actually occurred.
The official record.
The reporter's transcript on appeal at 9:26 a.m. on November 5, 2025, the court called the case.
Shit.
Noted petitioner's absence, appointed a privately retained reporter pro tempore because no official reporter was available, dismissed the matter for non-appearance, permitted respondents' counsel to reserve attorney's fees, and adjourned. The entire proceeding lasted as long as, never mind, I better not say what I'm thinking, approximately 4 minutes. That's not a very long love session.
November 4, 2025, the day before the DVRO renewal hearing.
At 10:05 a.m. on November 4, the court emailed all parties that there was a high chance would be available the following day, and that, because this was a DVRO trial, the matter would need to be continued if any party declined to waive. Petitioner relied on that representation. She did not waive.
What followed was a series of miscommunications. No, what followed was a series of communications from which he was entirely excluded.
At 10:05 a.m.
5 minutes after the court's all parties email,
Oh, damn it!
respondents' counsel emailed the court directly, without petitioner, to inquire about securing a private reporter. That discussion continued through the afternoon. At 3:32 p.m., court staff asked whether the proposed reporter was certified. At 3:42 p.m., respondents' counsel confirmed one had been secured. At 4:08 p.m., I farted. No, just kidding.
Oh.
Court staff asked for her name and license number. Petitioner was not copied on any of it. Not one jot or tittle.
She was added to the chain at 4:40 p.m. after the reporter had been identified and approved through a process conducted entirely between one party's counsel and the court. Upon receiving that communication, petitioner immediately filed a formal written objection invoking government code bloody bloody poo poo and California rules of court yada yada schnirt schnirt, documented her exclusion, and explicitly declined to waive her statutory right to an official reporter. Under rule bloody poo poo, the court was required to reflect on the record whether each party waived or refused to waive. The mini minutes are silent on this subject entirely.
At 5:08 p.m., the first moment petitioner had confirmation the hearing might proceed. GPT M-, her family purchased emergency last-minute air travel from Scottsdale, Arizona, where she currently resides in the Meseta, to San Francisco for the following morning. She transmitted the confirmation to the court that evening. November 5, 2025.
The morning of the DVRO renewal hearing.
In the early morning hours of November 5, as the birds were chirping, the bees were humming, the horses galloping around the stable, Petitioner suffered a sudden and severe medical emergency. She was vomiting blood and was transported to Honor Health Hospital's emergency department, where she was admitted for we don't know what it is, procedure under anesthesia.
Oh, those poor bees that just got vomited blood all over, and they were the hummingbirds, and everything was just wonderful, and then blah!
I can't respond to chat right now. I'm in a zone. I can't do it.
I do it. Keep going. I'm paying attention to chat. That's fine.
At 6:21 a.m., more than 3 hours before the matter was called, petitioner emailed the court and all counsel describing her condition.
Oh my God. Okay, Satan, get your shit together. Let's go. You have a story to tell.
More than 3 hours before the matter was called, ChatGPT M-, petitioner emailed the court all counsel describing her condition, her hospital admission, and her physical inability to appear. She submitted medical documentation and offered, without reservation, to execute HIPAA authorizations permitting immediate independent verification by both the court and respondent's counsel. Court manager Francis Yokota replied at 7:11 a.m.
Email received. Thanks. End quote.
At 6:53 a.m.
Why are we going back in time?
Because that's all they do. They just go and recap everything to make it sound like it's bigger than it actually is.
We send an email, and then now all of a sudden we're back in time. When, as Jack Fox said, when you have to go back in time to explain things, there may be a problem.
53 a.m. petitioner sent a second notification. She was being formally admitted. The procedure under anesthesia was proceeding. She was expected to remain hospitalized overnight, and she requested a continuance. Court manager Yokota replied 7:33 a.m. Good morning, Miss Owens.
Good morning, Miss Owens. I shouldn't be mean to the poor court staff.
Yeah,
We received thanks. We've received it, you crazy bitch.
Commentary might have been inserted there just for the record, but yeah, okay.
Thank you so much.
The court received written notice of a life-threatening medical emergency. I can't say what it was because I have no idea. And maybe it didn't happen at all. But maybe. The court thus received written notice of the life-threatening non-emergency, accompanied by medical documentation that no one ever saw, and an offer of HIPAA verification that no one took, and acknowledged it in writing twice before the matter was called. No continuance was considered.
Oh no.
The verification petitioner offered was never requested. The case was dismissed in 4 minutes. The reporter's transcript contains no reference to any of this.
D. The consequences.
The record before this court supports only one inference. Petitioner failed to appear without explanation. That inference is false, and it forecloses the appellate review this case requires. It is also the inference respondent has been exploiting publicly. He has made statements, ChatGPT M-, both while the restraining order was actively enforced and continuing as recently as the date of this filing, M-, characterizing himself as victim of petitioner, a finding no court has ever made, and implying that prior judicial findings have been vacated or reversed, which is likewise false. My precious, false Trixie.
I might be getting carried away there. What else did Gollum say? False tricks. I was trying to remember the list.
Oh. Now you've sent me on another
Side quest.
quest. Fuck off. Jesus Christ, I hate you. Go. Just fuck off. I'm going to go figure this out.
Bilbo Baggins and not the ring. False Trixie. All those things.
What's the lines?
No. Oops, wrong button.
The November 5 dismissal was purely procedural, entered without any evaluation of evidence or determination on the merits. The incomplete record provides no corrective account because it does not reflect the circumstances that actually, like the actual and real cancer, produced the dismissal.
3. The motion to correct and augment the record has never been ruled upon and must be addressed before briefing.
The motion to correct and augment filed December 3, 2025, pursuant to California Rules Hoochie Hoochie Yada Yada Boo Boo and Code of Civil Procedure Sections Yikty Yikty Yada Yippity Boomdy Boom, sought to place before this court each of the categories of omitted material described in Section 2. It was not opposed or denied. It became unreachable when the notice of appeal filed the following day divested the trial court of jurisdiction. It has never been adjudicated. This court has authority under California Rules of Court, Rule 81555, blah, 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 to augment the record and include materials necessary to the appeal's proper determination. The materials at issue, petitioner's pre-hearing medical notifications and the court's written acknowledgments, her medical documentation, and HIPAA offer going once, going twice, her formal written non-waiver of her right to an official court reporter, her denied ADA accommodation request, the ex parte communications from which she was excluded, and her emergency travel booking are not peripheral. They are the actual predicate of every issue this appeal presents. Preparing an adequate motion to augment requires identifying each item with specificity, establishing provenance and authenticity, and demonstrating relevance to each issue on appeal. Petitioner did not understand this to be the necessary path, although she thinks she's got boobs big enough to be a lawyer, until legal counsel identified the record deficiency and the dispositive obstacle, not those boobs, to representation in the weeks immediately preceding this fight. He has moved as promptly as circumstances allow. He made a foundational step without no opening brief that can responsibly be filed, and 60 days is the minimum time necessary to pursue it.
4. Both attorneys who appeared at the dismissal hearing are the subjects of active state bar proceedings arising from their conduct in this litigation because I, Laura Michelle Owens, filed those bar complaints frivolously and maliciously. And if they haven't been already dismissed, they most certainly will be.
Prior to the November 5th, 2025 hearing, petitioner filed California state bar complaints, petitioner being Laura Owens, against both attorneys who appeared when she dismissed. Omar Raul Serrato Esquire, lead counsel for the respondent, who secured the dismissal and immediately moved to reserve attorney fees, and Rachel Elizabeth Juarez Esquire, associated counsel. Both complaints arose from conduct in connection with this litigation and were filed before the hearing occurred.
The bitch filed bar complaints as things are still going on. What does she expect that to do? The bar does nothing when there's active and ongoing litigation. Jesus Christ.
So she's getting shitty legal advice. It's probably from dipshit.
David's brain is smoother than a porn star's butthole.
Both complaints arose from conduct in connection with this litigation and were filed before I already read that. Sorry. Both complaints have progressed beyond intake.
So what? That's what happens. They get the form, they process it, they do a little sniffing. The attorney responds to the things being declared, and then they.
God damn it! That's another Tuesday in court. You dumb bitch. God, what the fuck?
I was listening to Radio Free Mormon, who hails from this part of the world, and who's very active in the ex-Mormon space. He had a shit ton of bar complaints filed here against him by a bunch of BYU boys who call themselves the cavalry.
I'm sorry, the who?
The cavalry.
Oh, the cavalry.
Cavalry. You know,
yeah.
one if by land, two if by sea. That cavalry. I got to be careful. Sometimes I get the L and the V backwards. That's wrong. So, you know, I know how this process works. Because he explained it. People file bar complaints. The bar looks at it. They talk to the lawyer. The lawyer responds. The bar council makes some decisions and see if there's any merit to it. This is not a gotcha moment. It's not.
They're that dumb. They literally are that fucking stupid that they think it is. But you know.
Well, you know, she tried the trick before when she did ex parte stuff and claimed grape against Greg Woodnick and so on and so forth. And I don't know how many bar complaints she's filed against him. I think 2 as well. Yeah. Anyhow, I digress. Sorry. I was just reflecting. It's like this is not a thing. And they're not going to act on it while there's an active case. They're just not. Because they don't want bitches like this using bar complaints to interfere with litigating an active case for that very reason. I don't know how she can be so fucking...
I wonder who she's learning that from. Cough, dipshit, cough.
He should know better. I mean,
you've read his blogs. We've analyzed his blogs. He's not that intelligent.
Yeah, maybe I'm giving him too much credit. You could be right.
You are giving him way too much credit, my friend. That is not no.
I'll keep going.
Each has been assigned to a name our trial counsel and has required the production of specific documentary evidence in furtherance of the state bar's evaluation. This misrepresentations on what? The misrepresentations under investigation includes public statements by counsel about the DVRO renewal proceedings, specifically statements about petitioner's whereabouts and about whether she offered or refused to provide medical verification and offer the documentary record. I think that's the wrong word. Confirms she made. The implications for this application are direct. Petitioner must prepare an appellate brief without counsel, although someone else may be in the wings anyhow because he can't get over this case himself, in a proceeding whose central facts are simultaneously under active state bar investigation against attorneys who are subjects of that investigation and who hold every structural advantage over an unrepresented party.
Boo fucking who?
Yeah. Aw, sad face.
Go run up one of mommy and daddy's other credit cards and get another attorney. I mean, that's what we're doing.
That's what they do.
We've got all this debt. Come on. Somehow we got money for Christian looters out of the thin air. Go hit that sugar daddy up, or I assume it's a sugar daddy. If I had any bets, I think I might know who it is, but never mind.
Oh,
come on. Please.
Okay.
Sweet baby Jesus. I mean, that's what happens when you self-represent. You're at a disadvantage. Tough shit.
Courts have recognized the fundamental fairness concerns this dynamic creates. Those concerns are materially heightened here. Heightened where? As here? What? The professional conduct of opposing counsels under active regulatory review for alleged misrepresentations about the very facts at issue on appeal. The extension petitioner requests is not dilatory.
Wow. Using words that are not in their vocabulary. Yeah, I promise this was massaged through, probably douche canoe GPT, among other places. I suspect. Allegedly, I believe. They're my beliefs. They're my opinions. I would like to see some discovery on how she writes these things.
That would be pretty good.
Yeah. Tricksy little hobbitses.
Uh-huh. That's
He hates it. They stole it from us. Okay. Moving along.
The extension petition request. Oh, next sentence. It is the minimum consistent with proceeding responsibly.
5. Petitioner has diligently pursued appellate representation and faces documented financial hardship.
Petitioner's pursuit of appellate counsel has been continuous and in good faith. The written declinations she received in the weeks immediately preceding this filing, from 2 separate sources of legal counsel, each of whom reviewed this matter substantively before concluding that the incomplete record precluded representation, are evidence of that diligence, not its failure. Both expressly invited petitioner to reapply once the record is corrected, confirming that the appeal was viable and that a clear path to representation exists. Her inability to retain private counsel is not a matter of preference. Petitioner is currently a party to bankruptcy that's being stipulated for dismissal, with a hearing scheduled before the U.S. Bankruptcy Court May 14.
Mark that date, folks. May 14 is the hearing for the stipulated dismissal, because that's what's before the court was going to be that.
The financial circumstances that necessitated that filing are the same circumstances that made a private appellate representation inaccessible. A 60-day extension would allow her to address that hearing, continue her search for representation, and pursue the record augmentation that must proceed before any meaningful briefing.
6. Not sex. 6. New conduct from a respondent requires investigation and may warrant independent legal relief.
Petitioner has identified conduct by respondent raising questions on 2 distinct legal theories, neither of which she can adequately evaluate without counsel.
How would she know? How the hell would she know?
Everything.
Oh my God. Deuce Canoe told me so. He told me there's 2 things you could do. I don't know. Maybe they gave her an initial consult and they had some ideas of how to dance around the appeal. I don't know. I'm just reading. We're just reading the document as
we're just reading. It's fine. And I'm making snarky comments in chat. It's fine.
Interjections as I see so fit for entertainment purposes only.
Obviously, just for entertainment purposes here. This is not proper, recitation or any sort of copyright whatevers.
And my poor sinuses are over this bullshit. They can't stand it. But we'll keep going. We'll drudge along.
Yep. Suffer for the cause. Echoes. Yeah, suffer for the cause.
I'm suffering for this.
First, when a renewal petition is filed before an existing order's expiration, the order remains operative pending adjudication. Blah, blah, blah. Petitioner filed her renewal petition on July 10, 25. The order, therefore, remained in force through at least November 5th, 25. Respondent participated in public media appearances. How dare he made during that period that were broadcast to a substantial national audience. That may be also known as Love Trapped, the podcast. Then, the then active order. See, is that right?
Well, it could be lots of things.
You know better than me.
Interviews. Mike was interviewed by Stephanie of Love Trapped. We heard his voice. He tells his story. His wife, Danielle, tells her story. We hear it. It's there. We're going to make accusations. How dare he say things about me, goddamn Laura Michelle Owens, before I have the chance to abuse him and silence him permanently. That's what's going on in that fascinating little noggin of hers. In my opinion.
Maybe there's something going on up there. I guess that's worth calling out.
Yeah.
I don't know.
Worth calling out. It's a whole pile of things in my layperson's opinion. Because I can't invoke other people who actually could make legitimate diagnoses this way.
Hey, we're allowed our opinions, under to opine under the First Amendment, because
I have refused the temptation to involve people I know intimately, shall we say, could take a look at all this and have some legitimate diagnoses. Aside from doing some standardized evaluations, paperwork. A lot of them stuffed out with all the material here, but never mind. It's a lot.
Yeah.
I'm sure it's a lot. But that's just my layperson's opinion on such things.
The then active order expressly prohibited respondent from disturbing petitioner's peace, harassing her, and contacting her directly or indirectly by any means. Those recordings contain material falsehoods about petitioner directly and irreconcilably contradicted by respondent's own sworn deposition testimony of January 2018, by audio recordings in petitioner's possession, and by contemporaneous text messages in petitioner's possession, reflecting respondent's own words, establishing that the misrepresentations reflect not a difference in recollection, but deliberate falsehood. The broadcast foreseeably granted sustained harassment directed at petitioner. Second, and independently, respondent has made public statements beginning in the period immediately following November 5th dismissal and continuing as recently as the date of this filing, containing the same category of deliberate falsehoods, (M-), contradicted by the same deposition testimony, audio recordings, and contemporaneous text messages, copy-pasted in my text, described above, distributed to a substantial national audience called Love Trapped, the podcast. Go check it out. I, not Laura Owens, the succubus of Scottsdale, say, go listen to Love Trapped. It's fantastic. The deliberate public dissemination of materially false statements about a person made repeatedly and to a national audience in a manner that foreseeably generates sustained harassment directed at that person constitutes conduct that destroys the mental or emotional calm of the subject of that conduct within the meaning of Family Code Section 6320. California courts have held that such conduct need not occur within the context of an existing order to constitute abuse cognizable under the DVPA. It is precisely this category of conduct that warrants the issuance of new protective order. Family Code, blah, blah. Determining the precise legal basis for relief and its full scope requires analysis petitioner cannot responsibly undertake without counsel. David Jinger says he's not helping on all of this.
Not on all of it. Okay.
Well,
That's
cool story, bro.
That's an assumption on my part. I don't know. Maybe. He may not be. I suspect he is. Rachel Juarez suspects he is. And when David lost his shit to Reality Steve and said a lot of nasty things about Rachel Juarez when she made that, I think, accurate assumption. They don't want that audio to get out because it makes Douche Canoe look even worse than he already does, which is kind of unfathomable to me. But I know, in my opinion, he's a raging misogynist, among other things. So there's that.
I mean, that does take some effort, to be honest. But
Yeah. Why are there so many damaged men that are raging misogynists?
let's see. How much more time do we have? Because I think that could go on for several hours.
We're near the bottom. We're near the bottom, but this was important.
We could go into high control religion environments. We could go into societal pressures. We could go into generational traumas and blah blah blah. But I don't think we've got time for that shit.
Yeah. Danny says, you know what really bothers her about Love Trapped? How successful it is. Everything she ever wanted to be. So right, Danny. She wanted to be rich and famous and adored like a celebrity, and she didn't get it because, quite frankly, and again, also my opinion, she has no talent. She's got some skill riding a horse, and, well, never mind. I won't think about those things because we would have to get
Dear God.
You know, that's sort of the thing you'd want to ask Clayton, you know, after a couple of drinks. Like, Clayton, was it any good? Was it at all?
God, I
You
mean,
know, not from a shaming standpoint, but just, does she have any skills with anything with BJ's at all? Or is it's just like, oh, okay, there's, all right. You know?
I don't know. Without asking that question, without actually like A/B comparison, I'm going to wager a bet that I'm probably better than her.
I think I would side with that bet too.
Just saying.
7. The balance of equities compels relief.
Okay, you know what? I might give it a little break. On one side,
It's even too much for you. That's perfect.
I need a breather. I don't have the air conditioner on. I'm having hot flashes from all this bullshit.
Oh dear God.
My fan, God damn it. On one side, a self-represented domestic violence survivor whose ADA accommodation requests were denied. No, they weren't. They gave you a continuance the first time. You don't get to continue it indefinitely, you selfish bitch. No, I want to abuse him forever. I want this to go on forever. No. Not how it works. You do not get to do this.
Mm-hmm.
Who suffered a life-threatening medical... Oh, maybe I do need this.
Who suffered a life-threatening medical emergency on the morning of her hearing, who notified the court in writing before the proceeding began, whose notifications were acknowledged in writing before the matter was called, who submitted documentation, offered HIPAA, who was dismissed, despite all this, who the day before...
This is like a weird laundry list. Who was this and who was that, and oh my God. Good night, Wallace. Thanks for joining us. Catch the rest.
Thanks for hanging in there this late. Appreciate it. Have a good sleep. We are not done.
Oh my God, this is going to be a late one, but we've got to read the Medium blog. We just have to, and whatever the GPTs have served up to you.
Yep.
This is almost.
I'm ready with the summaries.
Who ignored her and who didn't love her and who didn't worship her and who didn't. This reminds me of some literary reference that I can't think of right now for some reason. Who filed written objections, who filed a motion to correct the record, who did this, who did that. I'm going to skip a little bit. Is that okay?
Yeah.
Pursued appellate. I mean, it's like I'm such a victim. Give me a break, everybody. I did all the things and you're not giving me what I want. I need a Veruca Salt voice. I want it now. That's what's going on here.
Basically.
Who faces documented financial hardship evidenced by bankruptcy proceeding, who must proceed against attorneys under active state bar. The state bar investigation is irrelevant. Shut up. Subjected to sustained and documented harassment as a direct foreseeable result of respondent's public conduct. Oh, God. She's probably going to think anybody talking about this is harassment, which is law. It's false. People reading this stuff is not harassment. Evil bitch. She asked for 60 days, time that would allow her to correct the record or reapply for representation and brief this appeal properly. With what money? That's what I wonder. Oh, on the other side, a party who publicly solicited and raised in excess of $50,000. Yes, he did. Oh, I have not done a tally where things are at. Oh shoots, there it is. Let's see. I'm just because it's come up now. Oh, hey, look at that, folks. I'm going to just share this briefly. The Marraccini Support Me Fund, the GoFundMe, is at $64,465 raised of $100K. We are 2/3 of the way there. Congratulations!
We're getting there, folks. Let's do it.
So generously to Mike Marraccini. Thank you all so much for doing it. And thank you all for sending him funds in lieu of super chats and things here. We appreciate it. Mike appreciates it. Oh, my tongue is getting tired. All this reading.
But Echoes doesn't understand that I still expect a cut from the proceeds that would have otherwise gone. So he's probably working himself into a debt spiral with Cheap Daddy. And that's fine. I have a ledger.
Where's in a tizzy? That's a phrase in one of her songs. Get me in a tizzy. Songs. Yeah. one of her country songs when she thought she was going to be a famous country singer. Oh my god!
Okay, yeah, right. Yeah, just like Kash Patel's girlfriend that's like a country star, music singer, whatever. Okay.
Please.
I know. I went there. Whatever. Fuck you. Please continue. Are we gonna go to no, that's that.
Change tabs.
Are you gonna,
Thank you. Back to this.
yeah,
Who've
okay.
raised lots of money for his legal representation in this matter from an online community whose members have directed sustained harassment and petition. No. When you consume content, when you go out and seek it, that is not harassment. And regrettably, poor Rob Hayes, lawyer, wasn't able to get that far.
Yeah, that was kind of unfortunate.
That was unfortunate. Never mind. Harassment that flows directly from respondents' public portrayal of himself as a victim. He is. Evil bitch. Portrayal of the judicial record does not support. Oh yeah, it does. He was not found guilty of any physical stuff. Zero. Just because he wanted to get you away from him, and I'm not sure it was the best legal advice he received either. Of, okay, just sign a thing, sign a stipulation, and hopefully she goes away. Boy, they learned that mistake, didn't they? Nope, no stipulations.
Yep. Oh,
No.
learning. Yeah. Yeah. Okay.
Respondent stipulated to the original DVRO in 2018 rather than contested because he was tired of the debt you run him in, you selfish bitch. Oh my god. I'm losing it. The San Francisco Superior Court granted the 2020 renewal on the merits. The order remained in force for 7 years. Respondent has nonetheless made public statements, as he allowed to do. He's got free fucking speech. Free fucking speech. Okay, the F words are coming out. Sorry. It's after dark.
Oh, I'm so offended. God damn it. Shut the fuck up, Echoes. God, Jesus.
Clutch my pearl necklace. Drip, drip. Respondent has nonetheless made public statement contradicted by sworn I'm trying to remember if I read his depo or if I only read hers. Her stuff where she was accusing him. Oh no, I think it was just her filing. I'm not sure I've read his depo. It may not be out there. I can't remember. Of all her salacious stuff accusing him of dirty sex things and making that abuse. It's like, for some people, that's going for the throat is a fun Friday night. Some people are probably enjoying that very thing right the fuck now. Sorry, folks. It's adult time. It's Adult Swim. So if you're offended by language,
It's Adult Swim the moment that you went live and I joined you later. Like, come on. Y'all know what you're getting into when you tune into this shit.
January 18 by audio recordings and petitioner. Oh, there's recordings. Real? I want them. And by contemporaneous messages reflecting his own words, in which he portrays himself as the aggrieved party and implies that prior judicial findings have never been vacated or reversed. Neither is true. No prior finding has been vacated. No abuse. There's no finding of physicality. I've read this stuff. Oh my god. I'm going to say it, and that makes it true. The public campaign built on those misrepresentations has generated the more sustained harassment the petitioner now faces. No one's forcing you to watch this. No one is forcing you to look. No one's forcing you to Google your name. No one's forcing you to YouTube Google your name. No one's forcing you to search for yourself. Because I don't think there's anybody that's going to be saying nice things. And people are allowed to say not nice things. That's freedom of fucking speech.
Yeah. And it's not like you're sitting there. You're not sitting there in some Clockwork Orange level theater, like, with your eyelids pried the fuck open with some schmoo like dropping eyelets in your thing. No, that's not how this goes. Just stop reading the internet. Oh, you're so offended. Okay. Yeah.
Danny says,
fuck off. Fuck all the way off.
Danny says, I'm not offended, but After Dark does help avoid little ears. Yes, and that's why I have the disclaimer. And if people are ignoring the disclaimer, I'm going to be pissed. I'm going to be pissed.
That's not your problem. That is them ignoring the preamble and the warning about what's to come.
For all audiences, and if you ignore that, it's your own damn fault.
Yep.
You're a bad parent if you ignore the disclaimer. If you ignore the warnings and
with,
disclaimers, and your children put bags over their heads or listen to things they shouldn't, it's your goddamn fault.
look, with respect, parent your fucking kids.
That's my non-parental rant for today because I'm not a parent. I haven't been ever, and I intend to never. Other than maybe a fur baby again, maybe.
Maybe it depends on the abandonment going on in the apartment.
I watch way too
Adjacent.
many cat grooming videos lately, and it's just like, oh, I want kitties. There's some cute ones she has too. It's like, oh,
I know. Yeah, I know. It's the struggle's real.
It is. You could have a kitty, but never mind.
I gotta plug in my fucking computer.
By the same community as the respondent enters this appeal fully funded. No, it's not fully funded, not yet, but we're getting there, folks. We're getting there. 64,000 out of nearly 100 and something thousand. We're getting closer. And again, we thank you for your generous contribution to Mike Marraccini's GoFundMe. That's in the QR code above. It's in the banner below. And for those of you who like lo-fi, copy and paste, it is in the show notes as well. The 2018 restraining order, double chat GPT, which respondent stipulated rather than contest, was supported by. See, she's just. Oh no, napkin lady! Oh, napkin lady! What have I gotten myself into? See, I didn't pre-screen this. I need some crickets. Was supported by a sworn declaration from Napkin Lady Karen Ilmberger, a complete stranger to both parties. Seated directly in front of them on their December 30 flight to Iceland, Ms. Ilmberger declared under oath, why are we making it? See, this is like David arguing stuff that is absolutely unnecessary in a request for an extension of time. Which Lana and
just
Buffy
distract and deflect. That's what they do. That's what they've learned to do. David
Gingras' entry into Owens v. Eckerd was like 30-some pages, rambling on for an extension of time, where a page, maybe a page and a half if you really had to, was sufficient. But no, he went on for 30-something pages. And they read all of them. Can I skip some of this? Ms. Ilmberger declared under oath that respondent was
emotionally and verbally abusing Miss Owens for a long time. He was so menacing that I felt her life was at stake were she to stay with him. And that she was so frightened of respondent that she omitted her own name from the note she passed to petitioner because she was afraid that he would come after me if he found the note.
I'm calling bullshit on that. I'm not. While there is a person who may exist with that name, I don't think this is legitimate. I said it before. I'll say it again. I don't think the entire situation with Napkin Lady existed. And I suspect someone wrote a note on a napkin while poor Mike was hiding in the bathroom for a couple hours. That's my suspicion. God, I can't stand this. And to quote Llama and Buffy, God, I hate her so much. That account from a distressed witness. Oh, disinterested witness.
Who had never met either party has never been challenged in any court.
Well, it sure the hell should be. Let's get some discovery on that. Let's get this woman on the stand and let's cross-examine her. If she actually exists and says any of the things she's claimed to. Well, I should say Laura attributes her to having said. I'm suspicious. In the last edition of Love Trap, Stephanie reached out to Napkin Lady and had no response. I was going to play some of the last episode of Love Trap tonight, but there's too much. We've got too much. Because there's some good nuggets. Laura Owens and Stephanie Young, the producer of Love Trap, the podcast, did have some emails back and forth, and they were interesting, the context and substance of some of those things. So again, folks, go listen to Love Trapped. You won't be disappointed, especially the last episode. And there will be more episodes as need requires, as more news drops and Stephanie produces more. So there should be some sprinklings of additional as they go on. Blah, 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 blah. The renewal loss. I'm going to skip a little more. The DVPA, blah, 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 blah. That outcome is blah, 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 blah. Oh, do we have actually a conclusion? Okay, here we go. All right.
Conclusion. For the foregoing reasons, petitioner respectfully requests this court
grant a 60-day extension of time to file her opening brief.
Maybe I should stay over here. Grant a 60-day extension of time to file her opening brief, not bikinis. Extend the current deadline from April 28th to June 27th. Accept this application as timely filed prior to the April 28, 26 deadline. And grant such other and further relief as the court deems just and proper.
Petitioner hereby advises this court and places respondent Mike Marraccini on formal notice that independent of the outcome of this application, she intends to seek a new domestic violence protective order arising from respondent's recent and ongoing conduct.
Dated April 23rd, 2026. Respectfully submitted. Laura Michelle Owens, petitioner appellant in pro per. All the best!
Okay, we're done. That one's done. That one's done. That one's done. All right. Medium blogs next.
Okay.
Do you have some processing there, or should I just bring it up?
Well, why don't you bring it up as an entertainment value, to our audience, and I'll sort of read here what it sort of summarizes and sort of because I wanted it to stitch together the arc of what she's trying to, and it's only 3 posts, which I was kind of disappointed because I was expecting her to blather on like way more than just 3 posts, but okay. So
I need to read something really fast. Real Karsten says, this comment places Owens on notice that she is a twat.
I may have used that term about, 50 times this last week.
That deserves some
But
wooing.
to be fair, I was using that term to reference someone else and not
I know.
LO.
Okay, well, so do we want to AI this thing? My voice is starting to get tired. Or would you
Yeah,
like to
I'm like, we're just going to pull this up and we just leave that there. And then I'm going to sort of read kind of the synthesis of what Claude came up with here, my bestie. So
pages.
Yeah, it's a lot. And so I made it written by LO. Oh my God. So basically, what?
17 followers, 1 following. I just want to know who she's following.
Do it. Let's see. Who's she following?
Well, I don't think it'll pull up in the archive, but no. Medium staff. Oh, who cares? Official count for the
That's bullshit.
Yeah, all right. I don't care.
Okay, so the new post, what it says here.
Give the title.
What the new post actually argues.
The of Kristen Harden by Laura Owens.
By Laura Owens. It's an 8-minute read, so you'll never get these 8 minutes back in your life if you choose to read this. Okay, so just put that out there.
Some engineer needs to fix this problem because they're never the length they read, and I'm a quick reader when I want to be.
Yeah, well, I can be too, but also, ADHD brain tends to.
No, I will play. Other people have said this is essentially the same crap that she always does. It's all the Laura GPT stuff, and it's the same structure, and it's the same garbage. There's really nothing new here other than it's interesting to see what sort of bitching she's going to say about the person who was watching her being naughty at the horse show, where she should have been in California at her trial.
Right, suffering under medical conditions at her trial, but yet she's out doing horse show things. But yeah, okay. So I'm going to set this up just for a minute because I spent a lot of time looking over here, and architecting this.
Real Carson also. Hang on, just a second. I followed her so I could leave comments. Then she blocked my comment. All I said was she is a sophist. Oh, zing. Yeah, Laura doesn't like people defying her control.
Nah, and sadly, I also like maybe corporate daddy has a couple of people that are kind of like that also don't like their control and their thing being usurped by others. But that's a different rant for a different time, into the distant future. Anyway, my own digressions aside, I just disconnected my power supply, so like that's not going to work out well for longevity of this device. Okay, there we go. Okay, so summary: what the new post actually argues. Again, this is according to some AI shit, and I'm just going to read it and insert my own commentary. So I didn't want the brain damage. Serrato's fee motion frames Owens's DVRO petition as filed in bad faith. The pivotal factual hook in his theory, Owens told the court her travel was, quote, life-threatening to obtain a continuance of the October 21, 22 hearing dates, then was at the Scottsdale Fall Classic 2 on those very dates. Per the post, yep, there we go, highlighted. So no hallucinations yet. Per the post, his motion states, petitioner was present at the Scottsdale Fall Classic 2 on the very trial dates from which she had obtained a continuance based on a representation that travel was life-threatening. Hardin's declaration is the only evidence placing Owens at Westworld on October 21 and 22. Owens' rebuttal. October 21. She says she appeared in court remotely from her home in Scottsdale. Hardin claims to have seen, quote, a thin female with high ponytail and green top near Ryan Miller, unquote, while Miller rode her horse, Sirocco 91, and to have identified that figure as Owens, quote, based on observations the following day, unquote. Okay. Still doing good. October 22nd, Hardin claims that she saw Owens at Westworld at about 11 a.m. watching Miller show Sirocco 91. Owens says she was... What? Huh? What?
Something?
No.
The article.
Oh, no, you can't.
Laura says this. The entire premise of that, or this, she says, the observation that generates Miss Hardin's subsequent identification is impossible.
Mm-hmm.
Insert that for the record.
Okay, yeah.
Because then she says this. No one was present on the 21st. And then she runs to the security footage claim again. And Mr. Miller. Well, if Mr. Miller's in her camp, then he might cover for her because she's conniving and would go after him if he didn't conform to her whims. Okay, sorry. Go ahead.
Yeah, you're fine. Continuing along the October 22nd summary, Owens says that she was outside a Phoenix gastroenterologist's office 41 minutes from Westworld for a 9:30 a.m. appointment. The structural problem with Hardin's claim per the official USEF schedule. Owens links Sirocco 91's first class was October 23rd, so there was nothing to watch on October 22nd. Huh.
So what?
That's kind of funny. October 23rd through 26th.
You're not just going to walk a horse into a contest. You're going to be warming them up. They've got to be there for betting and,
Yeah.
You don't just drive up and push the horse out of the trailer and you're competing with it. They're there.
Here you go. Shove. Good luck, kid. Yeah, no, it doesn't work like that.
Dude, but even I know that about horses because I've been to a county fair or two. Excuse me.
Yeah.
I mean, the horses are there. They aren't just sort of dropped off and you ride them into a contest. Yeah. No, not that stupid.
That's not how that, it's not how that works.
See, she must think everybody's stupid. She's the smartest one in the room.
Yes, but that's like classic narcissism.
Thanks for coming, IB. Happy
Hey,
sleep.
IB, you're awesome. Have a good night. So continuing along on the timeline, so October 23rd through 26th, she attended October 23rd as a spectator and competed October 24th through 26th. Hardin Instagram video, October 27th, 3 days before signing the declaration. Hardin allegedly says she watched the girl ride, didn't know who she was, and, quote, started looking on the internet to identify her. Owens argues that's incompatible with a sworn certain identification declaration covering October 21 and 22. Okay. Milo v. Hardin, June 4. Huh? Milo? Okay, whatever. I'll take your word for it. Anyway, moving along to the important bits. Owens asserts Hardin previously lost a defamation appeal where the court found her statements about another equestrian's conduct were false assertions of a fact made with actual malice, used here for a pattern.
I would like to read
Noted.
that case. I'm not going to agree with her representations of this is what it says. Trust me, bro. I want to see that case for myself. Keep going. Maybe I can find it.
Okay, so notes to Serrato, she claims she warned him in writing on October 28th, 2025, named Hardin to him on October 30th, offered phone records, GPS, HIPAA authorizations, hospital and gastroenterologist verification, and reiterated all of it Jan 15, 2026, with an audio recording from the gastroenterologist's office. He filed anyway. She says she filed a California bar complaint against Serrato that had not been dismissed, quotes, as of the day he filed the declaration. So, kind of in summary, the structural argument here she's making, both to the court and to the public, is the classic anti-slap / bad faith fee defense move. Opposing counsel filed a sworn declaration after being put on notice that its central factual premise was false, with offered independent verification ignored. Okay, so that is like the overall summary. So moving along to what's
Her representations are not accurate. What I see of the case already.
Yes.
So
Yes.
the underlying case was a defamation case. And then it went to appeal.
Mhm.
So I've got the appeal decision date, which is from 2024. Strangely enough, what was going on in the water? The appeal challenges the trial court's denial of a special motion to strike pursuant Code of Civil Procedure, the anti-SLAPP statute, directed at a complaint filed by plaintiff Samantha Milo, asserting a single cause of action for defamation against defendant Kristen Hardin. We affirm. See, I'm just trying to read all this because it's not thick.
Well, it's not super thick, but also like let me work through some of these contestable pushback on type arguments here, because there's what?
I'll keep reading this and you talk.
Yeah, go for it, and highlight as we go here in case something comes up. So there's 7 points. 5, 6, 7. Okay, there we go. I can do fingers. So number one, the life-threatening travel representation isn't quoted. Owens repeatedly characterizes Serrato's framing of her continuance motion, but never quotes her what her continuous motion actually said. That representation, its exact language, is the entire ballgame. If she said life-threatening, the bad faith argument is much harder to dispatch with USEF records about which day her horse competed. Now, again, this is all framed from the perspective of the blog post. I literally linked this to the AI. It processed it. So keep that in mind. I'm not asserting and nor is Claude asserting a fact. It's literally just processing what LO is trying to assert here. Okay, so don't at me on this. Number 2, the I wasn't at Westworld claim and the I competed October 24th through 26th claim aren't the same defense. USEF show records prove which classes a horse was entered in, not whether the rider was physically on the grounds on a different day. Westworld is a sprawling complex. Quote, Sirocco 91 didn't compete October 22nd. Doesn't prove Owens wasn't there for any other reason. The stronger evidence, security footage, GPS, gastroenterologist verification is offered, but it is not produced in the post. So she's just making the claim. Jesus fucking hopskitching fuck. Number 3, the timing problem she elides. The hearing was October 21 to 22. She competed October 24 to 26. She was hospitalized November 5th. The fee motion's bad faith theory survives if the question is, quote, is it consistent with good faith to seek a continuance citing severe health constraints, then ride competitively 3 days later, question mark, unquote, not, were you literally at Westworld during the hearing, question mark, unquote. She answers the second question and ignores the first. So, okay. Number 4, the hospitalization timing is doing different work in different posts. December's eating disorder essay pinned the November hospitalization to the night of the superseding indictment. The new post pins a November 5th hospitalization to, quote, the night of the superseding indictment, unquote. The new post pins a November 5th hospitalization to emergency surgery the morning of the SF dismissal. This could be the same event told 2 different ways, 2 different events, or one event reframed for 2 different audiences. It's totally worth verifying against actual hospital and court records before letting either narrative stand. Number 5. We got 3 more, folks. Hang in there with me. Number 5. Bar complaint not dismissed is rhetorically loaded. The state bar complaints sit in intake routinely. Not dismissed is the default state for months. It's not a finding of merit. She knows this. The framing is designed for the readers who do not, or at least her best attempt to try and frame it for her readers that may are just like ignorant of like court shit. Whatever. 2 more, and then I'll let Echoes talk. The Milo v. Harden citation, specific enough to verify CalCT app, June 4, 2024. I don't know what those acronyms are for. I haven't independently confirmed it, that being Claude. If it's real, it's genuinely strong pattern evidence. If it's mischaracterized, then I'll cut it hard the other way. It's worth running this down before quoting it on air. Well, I just quoted it on air, so go fuck yourself, Claude. Number 7. Coordination implication. She drops it in the, quote, only accounts that posted anything about me in connection with the show were the Justice for Clayton Instagram page and Harden's own social media, unquote. That's a coordination innuendo without a direct allegation. It's convenient if true, but it doesn't. But not provable from what she's shown. So yeah. Also, I find it very interesting that as I was scrolling through this and I looked at the prompt as it ended, I got this interesting little screenshot. If you are someone you know is having a difficult time, free support is available with a drop down for find resources. Chat now or text 988, call 988, browse resources. So clearly I'm stepping on some edges of Claude and Opus 4.7 that's triggering some of the safety mechanisms here. I just found that kind of interesting.
That is slightly amusing.
Yeah. So yeah. Yeah, let's see. Is there anything else interesting that it did in this analysis? I'm kind of scrolling through here.
Scrolly.
Yeah, like I could pivot to the Gingras or excuse me, the gin grass parallel here. But
like you drink and grass like you mow.
yeah, gin is good though. Gin's really delicious. So I think, I don't know, maybe like the snarky take here is this summary, like where the post quietly walks past the harder question. So like, here's again, a summary from AI, right? All caveats apply. Here's what she carefully does not address. The hearing was October 21st and 22nd. She competed October 24, 25, and 26. She was hospitalized November 5th. She spends paragraphs proving she wasn't physically at Westworld on the 21st and 22nd. Fine. But the fee motion's actual question isn't, quote, were you in two places at once? It's actually, is it good faith to ask a court to continue a hearing on health-related travel grounds, then enter jumping classes 3 days later? Question mark. Close quote. She doesn't quote her own continuance motion anywhere in the post, not once. The exact language. Huh?
What a surprise.
I know. Shock.
Shocker.
I hope you're sitting down for that, Echoes. I hope that our friends on chat are sitting down for that one.
I've been sitting down so long my butt's tired.
I know, it's getting there for me too. But like the exact language of what she told the court is the entire ballgame, and it's the one document conspicuously missing from a post that links to USCF schedules and Dropbox PDFs. So yeah, that's what it is. And look, yes, Danny, Claude doesn't want liability. I get it. There's other safety mechanisms in place with all of this stuff. I think the analysis though is on a majority on point. Is how can you claim that you were so ill that you couldn't appear in court, but then you have evidence from at least a couple different sources that you are actually at the competition? I mean, yeah, come on. Bitch, try harder.
Imagine that.
Yep. And Martini V, to the couple comments there, this is why it takes me a while when I'm using AI for this stuff, is because I want to frame it and I want to make sure that like I'm setting this up to a point in which I'm reducing the potential for hallucination or just making random shit up. I have more work to do when it comes to this particular project, in that, and this is where Claude is worlds better than. Uh-oh, did we just get bumped?
What do you mean?
I don't know.
No, I don't think so.
Well, it stopped streaming on my TV, so that's why I'm
Mine's still here.
okay. All right.
Your computer's crashing out.
Yeah, maybe. I don't know. Whatever. I'll just continue as though we didn't have any
Amy
problem.
says we're still here.
Okay. All right. Okay. So, yeah, maybe it's just my Apple TV freaking the fuck out. Okay. Anyway, so this is why I take my time. And the thing that I like about Claude more than I like about ChatGPT right now is I can I can be extraordinarily prescriptive about the way I'm boxing the request in to not have it sprawl too badly and reference and research certain aspects and also source it from actual material. So the one thing I found with Claude versus ChatGPT is that I can feed it like Jen Grass, the dipshit douche canoes website, and it is actually able to parse it where ChatGPT currently is not. So I can actually get the full story arc from Claude versus when I asked ChatGPT to do it, and it's like, oh my god, I can't actually like look at the whole thing. So that's what I'm impressed by that particular perspective, and that's why I shoved Echoes into the corner for a minute and made him suffer through some of that dramatic reading, is because I wanted to stage this in a way that framed who's involved, the scenarios, previous chats I've had, summaries about that, all of the things. And then I'm like, okay, go after this particular medium entry and tell me what it's all about. I will gladly give you the prompts that I gave it so you can do all the auditing that you would like. So I just the output is conservative in my opinion, but it's also well framed in telling a little more of an honest sort of analysis of here's the whole picture. And in future episodes, if I have my way, I'm going to build a roster of all these characters involved throughout the entire, like I've literally called this project in Claude, I've called it the Laura Owens universe. And I'm going to feed it all of this stuff, all of these PDFs, all of these documents, all of the court filings. I'm going to dump it into this particular project and give it that context. This is something that ChatGPT was not able to do, but Claude is. And it's like, okay, I want to see what it's capable of. And this is an excellent example with an excellent synopsis that sort of rides that border of like, it's actually quoting the documents because I kind of told it to, and they don't make shit up. But also, where are these weird edge cases? Call out this weird behavioral shit. It's going to learn that over time, which is delightful for Echo's benefit, honestly. And this is why I'm going to charge him a metric fuck ton of money when he's like rich and famous and popular.
What?
You
Rich and
heard me.
That'd be nice.
You fucking heard me.
I'll take it. Where can I get me some of that?
Yeah. Oh, you're working on it. So,
man.
but anyway, yeah, so that's kind of the theory behind like why I'm doing it, like why I've approached it in this fashion, and I appreciate the analysis that ChatGPT has given. And I've done a similar thing with Gingras blog, because again, I had like before I had to take each one, and sometimes I had to literally print it to a PDF and then send it into ChatGPT for some of this stuff. Which is so fucking painful. So painful. But like, I mean, it worked because that's what I do. I make shit work for all of you who are watching this either live or in the replay. And I did it again in the context of this framing of the Laura Owens universe for Gingriss's blog. But I don't know. I feel like we're at 3.5 hours at this point on this live,
Yeah,
and I feel like
I'm
I feel
fading.
like I feel like I need to reserve this for later, for a future stream, because poor Echoes, his cubby hole gets a little chilly at about 10:30 Pacific
No, it's
time.
really warm right now. Sweating it out under all the equipment here. I need to
Well,
turn
I
on
mean,
and air it out. That's
well,
what.
okay, but I don't know. I don't know. It just that's where things are at, and I'm happy to let the robots and analyze this as long as it remains factual. And so far, it's kind of like stayed within its rails. Like I don't know, Echoes. What do you think? Has it stayed sort of within? You know.
The only thing I would add for a little nuance is how Laura chooses to use Milo v. Hardin as an attempt at impeachable evidence against Hardin and the declaration for seeing her. It's a ham-fisted attempt at impeaching, and it's kind of pointless because this isn't before a judge, so it's stupid. But the high level, I was kind of skimming through the case and also looking at what Copilot was saying about Milo v. Hardin, and as I was sort of alluding to briefly earlier, the underlying case is a defamation case, and it surrounds a situation where Milo had some horses. I think Hardin was in attendance. They were at a horse show. Someone brought horses that were evidently, and if I'm reading this correctly, exposed to the equine herpes virus. Other people got concerned. Hardin did something a little bit naughty and started posting things on Facebook and making accusations.
Mm-hmm.
Other summations. So what it turned into was Milo decided to file a defamation lawsuit against Hardin. And Hardin's response to that was to, and this I'm scratching my head, shaking it at the same time, was to file in response an anti-slap lawsuit, which
Yeah.
may not strategically be the best thing if someone's coming at you with defamation. So the trial court shot down her anti-slap. She appeals it. So I'm not sure what the disposition of the case is now, if it's actually been decided, but it got turned back into a defamation case, and I don't know if it's been resolved yet. So, mind your P's and Q's. You can't just accuse people's horses of things either, and then spread that all over social media and say, hey, their horses spread around horse herpes. And everyone's been infected. They claimed their horse was immune to horse herpes. No, come on. Let's not be absurd.
Oh, but I posted it on a site, therefore it's true. My God.
Ms. Hardin made some declarations that appear, if I read things correctly again. So, again, take it for what it's worth. She appears to have made Facebook statements that were damaging and not supported by factual evidence. And then she was pursued for a lawsuit for defamation over that, and that's what the reference is. That, however, so that aside, it has nothing to do with Laura claims about it being about equestrian whereabouts and conduct the court rejected. The conduct the court rejected was an attempt at an anti-slap, which is procedurally awkward with the defamation case. I mean, I could see the two being linked together, but yeah, that I don't know. Maybe she was representing herself. I have no idea. It doesn't say. Does it say if there were any attorneys and what the representation was? Not sealing it here in sort of the trial breakdown. I'm also looking at this more in large form on CaseMine.com. You can actually just Google Milo v. Hardin and find it, folks. So if you want to look that up yourself and do a little more research, you can. But however, regardless of what happened in this particular case, and this is where I'm going with it, just because there was a Facebook fight over who said what and who accused what of whom and did this, that, and the other, which apparently did go to trial and then an appeal for anti-slap, that does not preclude Hardin from making observations that Laura Owens was in attendance in Scottsdale at the Westworld whatever horse show.
Yeah.
It's a ham-fisted attempt in Laura's Medium article to impeach her credibility with this case. These two are not they're not connected. These are separate issues, or separate matters. One does not, correlation does not equal causation, or vice
That is
versa.
correct. Yep.
That's what I'm trying to reference here. Just because Laura says, "Oh, there was the court case, and the court said some things and didn't favor her," that does not mean that what she observed, as it pertains to Laura Owens being present, to be inaccurate. That would have to be something a finder of fact would determine.
Mhm.
They would have to be put on the stand. We would have to have testimony, and credibility would have to be ascertained. So there's that. So this is piss poor. This is a piss poor character assassination to try and invalidate the declaration that Omar used for Laura being abusive against Mike Marraccini and trying to have a permanent DVRO in perpetuity for eternity.
Yeah. And honestly, like the goal that I have with playing with a very, very different AI structure with this is to build a cast of characters, to define their roles, to look at their history and sort of have that profile. And then also like permalink as best I can. Things like Jen Grass the Dipshit's blog, Elo's blog, even the JFC Instagram posts, all of this stuff, and have it be able to pull in all of those contexts every time that I will throw a blog post or something like, oh, Dipshit's got a new blog post. Let's take a look at this. And he's criticizing JFC Insta. Okay, let's take a look at that. Or, Echoes was earlier before I jumped on was talking about the Twitter JFC truth bombs thing. Cool. Let's take a look at those. Where's your citing? Where does that correlate across all of these? And that's the thing that, like, as long as it's fact checked and is sort of looked at by humans, that's a really interesting thing for these robots to go after and go take a look at. And all of these PDFs, all of these filings, like just toss that all in, toss it all into the mix, and let's see what it comes up with. Maybe it's all hallucinations. Maybe it's all fucking fake. But I mean,
It's good
that's
to check
why
your
we
work.
sit here and talk about it and check your work and show it, show
Check
your
your work.
sources. And those are some of the, for those out there, like Martini V, like this is the premise in which I base all of my prompts and like my baseline instructions. Like there's the system prompts that happen with AI that I don't, I or you or anybody never see. That's just how it operates. But then like you have your memory and like your operating instructions and like specific project things. So I lay a foundation of don't fuck with the facts. Don't make shit up. Don't speculate. Stay away from places like Reddit where there's like trolls or like 4chan or 8chan. Like, don't source those as authoritative references. Source this document that was actually filed in court because that's the thing that's real. So analyze this messaging and this text and maybe look at it from like the ARS live website, which Claude's capable of doing. ChatGPT maybe not so much. Copilot's just like in the corner, fucking shaking and thinking it's good enough for anything. Whatever. And Grok is just a fucking Nazi, so whatever. Or I'm sorry. Oh God, I used the word. Sorry. Whatever. Shit. I just entirely fucked up your stream.
That's all right. Let's
But
go to what Becca says.
yeah.
Becca says it went all the way to the Supreme Court on the anti-site, but I can't find a decision on the suit itself. Yes, I can't either. But again, I'm not digging too deep, so there's that.
So regardless, that is how like I frame that. And so like if I were to throw a prompt of like that very question, hey, look at this, and like it went all the way up to the Supreme Court on or around the state, like look at all of the publicly available data that's there. Source your material. Tell me where you found it. Don't make shit up or extrapolate things. Just speak on facts that you find from reputable sources. And honestly, it does a pretty fucking good job of that. And you take a look at it. Well,
You can at least get overviews.
yeah, you can get a good summary and you do your own looking and research at it, but it gives you a really fucking good head start.
Martine says, I'll stack her lawsuit against Laura's indictments. Touche. Yeah, someone's... I mean, okay, people get in social media fights. I've had my fair share of them, and some people want to start waving their saber rattle of, I'm going to sue you for defamation. Well, okay, do it. The people who've tried to do that to me have not done so because it would be difficult for them to factually prove what they claim I said, especially when they think I'm a bunch of randos on the internet, which I'm not.
Yeah.
Like, you can't attribute everything you don't like to one person, just the way Laura Owens can't attribute everything she doesn't like, being Greg Gillespie, hacking her computer. It's absurd.
Yeah, okay. Yeah, what a ridiculous concept. Okay, I want to respond to a couple comments that just showed up. So, Robin. Yeah, Robin. I would love to find a way, and maybe I will create a GitHub repo with a lot of this stuff in there that is actually like on one of those public sites that might have a summary of all these things.
There is. All the best research and timelines. Is that right? Yeah. Has a Padlet, which has the chronology with supporting documents. You can get lost in that for months, if not years.
Well, see that again. That's why I send off the robots to go do the thing.
And a lot of those, if you give it time to load on the damn page, because Padlet's a little bit slow, you'll get the documents, you'll get videos. It's got a whole bunch of stuff. So all the best research. Just Jen has been very busy there. Some others. Hey Bales is another one, whom we haven't heard from in a little while. So hopefully they're all doing well. Most of us are kind of caught in the real world stuff right now that's happening now.
Jesus fucking hop skipping fuck. Yeah,
archival documents that new eyes are coming to this with. So they all go to some of the older sources that they're not always the most current, but you can go back to the beginning. Just like Volo, victimsoflauraowens.com, which has a lot of the current trial documents as well as historical information, including David Gingras being indicted for inappropriate minors.
Yeah. Well, that sounds like a lovely second chat or another chat that I could spin up within that project.
That one we might have to do on Rumble. I might have to, because Megan did this. Megan did this with four ladies. I was talking about this at the beginning of the show. And
I heard you a little bit.
Yeah.
Remember I was stalking you? Yeah.
Yeah. And the other part of it was she also played the video of David Gingras threatening to sue her again in federal court and all that bullshit. So just because of copyright and YouTube shit. And the sensitive nature, she took the second half of that show to Rumble. And I watched the whole damn thing. And she went through the documents and read the stuff of that young lady that allegedly was assaulted by David Gingras.
Jesus Christ.
Dark stuff. Dark, awful stuff.
I gotta wonder, because I've already done some prompts and queries with Claude that have tripped over several safety mechanisms.
I should send some of it. Have you seen some of that stuff and tried to process it that way?
No, I haven't. Send it over. I don't give a fuck if Anthropic tries to block me, because I will crawl a mile up their ass and get that undone. But
really bad. And I know this story. I've known this story since those documents, that case. Because of research, I don't necessarily talk about it all, but I use it to inform some of my decisions and thoughts about what and how I talk about things. But I saw it when I dropped, and I fell out of my chair. I'm like, oh my God. I mean, this guy. Let me be frank here, folks, just for a minute. I don't want to be gratuitous because, we know people are listening, but had he been prosecuted fully, I think he would have been labeled he would have had to register as a level 3 sex offender.
Oh, as an SO? Oh my God. Okay.
Yeah, level 3 for sure. He was facing multiple level 6 felonies. And when he was, I want to say it was just after he was indicted, he fled to California. So he was a fugitive on the run for a little bit. It's all there, all in the documentation. But her testimony,
Wow.
the minor victim's testimony is there. Some of the questions that she was asked under polygraph are there. It's horrific. It's absolutely horrific stuff. Now, I'll be
I'm a
fair.
little, okay, to be clear, I'm a little sus of poly influenced question. Because
Sure.
that's not that there's a lot of that that's been thrown out and there's coercion involved with that. So just want to toss that out there for the record.
Amy, that part of the stream was the second half she had exclusively on Rumble. So if you are not a Rumble member there and you really want to hear what they talk about, because the ladies, all 4 ladies, have some very deep and personal reflections on hearing all that information. And even Roz made some interesting, what's the word? Not connections, but just viewpoints that perhaps, and this was just Roz's opinion, and I hope I'm stating this fairly accurately. But again, go see it on Rumble, Megan Fox on Rumble. Roz was saying that maybe some of what happened with that case that did not get prosecuted has to do with his infatuation with being involved in trying to save Laura Owens. That was something Roz had opined on, and I thought it was something I had considered long ago myself. Maybe not. It doesn't matter. But it is when you go back into the life history that shapes and informs who people are. It can change how you perceive them, and when you realize that someone has that kind of history, allegedly, that can shape and inform how you think of them now and their behavior now, which is still, in my opinion, abominable. And I still think he should be disbarred. That's not going to change. And whether or not he's on Twitter X, targeting people, well, whatever. I still think he should have an ignition interlock device too. I'm not going to settle for that. The guy hasn't yet been prosecuted for his DUI. That's coming up eventually. There's a hearing. Or is it the trial? Oh, see, now I've forgotten already. It doesn't matter. We'll see where that goes. I mean, there's so many things. There's so many things. We've got a lot of damaged people who are pieces of work, is about all I can say at this point. Evening.
Yes. Okay, so 2 more things that I want to, in comments that I would like to address. One was, let's see, where did it go? The real Carlston, remember that this is LO. Facts and sources don't matter. I do. I absolutely keep this in mind. I don't care what LO's opinion is about it. I care about what's actually filed, what's actually in the record. And that's sort of why one of the reasons and the motivations why I use an AI system to aggregate this is because it's going to pull in the information that I'm asking it to, and not some I'm asking it to correlate several different things right off different sources that are known, like maybe from an ad fontes media bias sort of perspective of I'm like, you're way over on this extreme. You're way outside the common bell curve of whatever thing we're looking at. So I'm doing my best to keep it within reasonable, sane things. Because again, I give 0 fucks about what Laura has to say or opines about how I'm processing or presenting this, even in this limited forum. I'm just a Jeep dude. That's what if you go to my channel, I'm there to show off-roading videos. I'm not and bitch about people leaving trash on the trails that eventually shuts it down because of limited resourcing with the state and with Department of Natural Resources and stuff. I that's not my bag. Is this hyper analyst giving a fuck about what Laura or what Gingras or Ratatouille or whatever the fuck his name is that's trying to represent him in the Rosada. I don't care. I care about what actually is being presented and what's being written about, and analyzing dipshit's blatherings on his blog as it compares to like what the actual state or the state's ARS would say. So rant aside, I don't care what LO thinks. She's welcome to come after me. I give zero fuck. Bring it, bitch. Fuck around and find out.
With
Fuck
someone facing
around and find out.
with someone
Okay?
facing 14 felony charges for being a fraud, essentially, if we just distill it down to everything, for having
Correct.
immense and unending credibility issues, who, by all accounts, appears to be a pathological liar.
There's
For
there's plenty of evidence on the record and convicted that she fucking manipulated things and did shit that she wasn't supposed to do, making up sonograms. God damn it! Like, fuck you, Laura. I don't care. I don't care what your opinion is. Okay, I don't fucking care.
Trish Jax's mom. Apparently, LO rejected the plea deal, so the trial will be happening according to Schnitzel Ninja. To which there has been an addendum. Trish Jax's mom. I covered that at the beginning. There has been some walking back a little bit of the phrasing. Now they're saying that plea deal stuff is ongoing, just like the RavGen test was ongoing. So it's still my opinion that it's not going to get to a plea deal unless she gets let off the hook. But we'll see. But they have walked back those statements. So I just want to be clear about that. And I also want to be clear again that all that horrific stuff about David Gingras is available to see on Victims of Laura Owens. Just go under the lawyers tab and you can find him. You can look at his past cases, his past DUIs. But again, he was never prosecuted. He was not charged nor sentenced from prosecution. He was let go. And take that for what it's worth. It's, in my view, and again, because he was let go, I'm going to kind of stick to allegedly, but everything I read in that awful case seems to me, in my view of reading it, in my opinion, is a little more than just being allegedly happened because of the way things are stated, the way things are read, the evidence and the facts of the case. So I'm allowed my opinions on that. This is why I don't think he's a good person.
As am I.
Just like I don't think Laura Owens is a good person. I struggled to weigh, and it doesn't matter because I don't need to weigh them. I struggled to weigh who might be worse. One's vindictive and litigious and goes after and burns down everybody's lives. The other one, allegedly, has a predatory history of criminal intent.
Yep.
And he knew it.
And like I said before, fucking bring it. I don't care.
Yeah.
Fucking find out. So the last thing, okay, so like that's the first comment. The second comment that I want to like just touch on just for a second is Maritime V asking whether Claude can handle all of this context. It's up. We've got a little bit of activity in chat, but I'm about to find out. Like, that's just the reality. I'm going to find out if it can handle it. Because ChatGPT was doing okay. But for me, the month of May is Claude versus ChatGPT. And we're going to find out just which one is going to do. Because I'm not just using it for this. I'm using it for a myriad of other things in my life right now. And so I'm putting it to the damn test. So yeah, we're going to find out if Claude is actually up to the task of tracking all of the people in the LO universe and all of these filings and all of this nonsense and custom instructions, specific memories for it. We'll see.
Ooh. That's a lot.
It is.
Well, I mean, if you try and dig after it, it's even more immense, isn't it? Trying to string it all seems like a lot.
Yes, and that's sort of why I'm using like a second brain for this sort of thing, because I don't have that kind of room in this poor over functioning brain. I can't. I got look friends, I have laundry to fold.
Yeah.
It's not. It may or may not happen, but quite frankly, I'd rather save my brain space for folding my laundry and washing my coffee mugs than committing to memory all of this shit. And so I'm going to offload that to this AI thing, mostly for Echo's benefit, because that's
God
how.
help me.
Yeah.
Let's see. Oh, I
Because
lost you.
again, my channel and my life is not about this. Mine's about going out and getting my Jeep dirty and seeing things like this lovely background
Pretty
and
pictures, as they say.
yes, and figuring out how to pull people off of the road or a trail when they think that their little precious Subaru or Toyota Camry can go on these forest roads and they need a friend with a Jeep, and I'm going to go rescue them. Anyway.
LMP says, oh, he was charged apparently, but the case was dropped due to misconduct of the prosecutor. If I'm wrong about that, correct me. No, that's generally correct. Some of the sequencing is a little fuzzy in my head, but just to show you where you can read more about it, you can go to lauraowens.com/David-Gingras. Now make sure you spell it correctly. And you can read the whole thing, and all of the blue things are links to the materials. So you can read about the entire thing and be a pig in slop to read about all of that. What I want to say that was that he was arraigned. I can't remember if he fled and then was arraigned or if he was arraigned and then fled and then turned himself in. I can't remember which way it went. It's all in there. I think I've read through this at one point in time. But they even have some of the sample questions here just in the write-up of this case. And it was from 1997. She would be roughly our age now, which is just horrifying. It's terrific. But again, if you want to go hear more about that, Megan and the girls talk about it wonderfully. And it is hard. Megan, Roz, and maybe some others to get a little teary because it's a difficult case, right? Anything involving minors and this sort of conduct is a difficult case, especially for people who may have experienced it personally. So I totally get it. I was listening with just attentive ears and not chatting for the most part because I wanted to hear what these ladies were saying about this entire thing here. But they talk about it well. Megan reads through most of the documents well, including, I think, she read through the report. I think she even read through some of the polygraph stuff, which shows up here too. So you can read through the whole thing. It's all here. All right, but I don't want to get into that one. It's too heavy for this juncture.
We don't need to go. We've got like literally less than 2 minutes before we hit the new record of 4 hours.
Yeah, Buffy and Llama have been doing that, so I feel like we're in good company.
This is a lot of shit to look. It's a lot of shit to go through, right?
There was a polygraph, Amy. There was indeed. There was a lot, and I think had it not been for the case being tossed from prosecutorial misconduct, all of her cases apparently were tossed because of what happened in one specific case. So all of them got kicked, which is disturbing to me on some level. I would think there'd be independent review of each case. Because God forbid, and maybe this is the case, I've not reviewed the details of that prosecutor and the circumstances. God forbid there was a serial murder runner, some homicidal maniac running around that was just, we'll let you go. God forbid.
Right.
So, but I haven't dug into it that far because, quite frankly, I'm not sure I want to know. But he was one of the let off the hook, in my opinion.
And again, that's sort of why I tossed the robots towards this. Regardless of whether Claude or GPT or Grok or Copilot or whatever is better than the other, I'd rather it go and synthesize that and help me understand it from a little bit of a distance. Just keep like an arm's length distance around it.
Your neurospiciness needs that. I don't mind reading the actual words and going, holy hell, what am
I don't mind it either. Trust me, I don't. But I kind of want the TLDR at the top of it.
Yeah, fair enough. I mean, some people just like that. I'm okay digging in. I'm just that way. That's just me.
I do too. This is a lot. And there's so many, like if you think of those boards, like A Beautiful Mind, the movie, where there's dots and strings and things like connected all over the place and stuff, right? Like that's
Yeah.
it's very, very thick.
Amy's over here dreaming about putting Laura and David on a polygraph. That would be
Ooh,
that would be very entertaining.
that would.
My goodness. Well, and as the final thought, the whole interesting thing about the Laura Owens verse is that there's so many side quests you can go on for months and days and years. Knock yourself out, and it just keeps growing more tendrils as this thing goes on. So the gift that keeps on giving. For good or ill, hopefully justice will be served. And again, all the stuff to support Mike, they're up there, they're down there.
Yep.
Do the happy things, including you, replay crew. I'm talking to you, replay crew, at hour number 4. God, I'm crazy. So yeah, all right, we've had enough, I think. So I'm going to play it out with a little bankruptcy nonsense because the bankruptcy is entertaining. At least the phrases I hacked together from the bankruptcy proceedings with the little beats behind it. That's good stuff. And I'm going to bed.
It is.
So thanks everybody for joining us.
Take good care of yourselves, folks. If you go down this deep dive thing, like make sure that you're taking care of yourself. And if it's too much, just pull out like whatever, put it away, touch grass, go get some fresh air, whatever.
I took time after reading it too. I took a couple of days of reading the whole story because I'm like, holy stuff, what did I just read about?
Take some time. Yeah.
Yeah.
In the meantime, and between time, to steal somebody else's line, please mash that like button. And if you haven't subscribed, please consider doing so because Echoes has got some good shit going on here. And do
also the notification bell so you know when we go live and when I post things because I'm pretty active posting breaking
He schedules
news.
the stuff. He's good about scheduling shit. Sometimes he doesn't tell me, and I have to look on YouTube for when the next fucking live stream is. So
he doesn't have his bell hit. He needs to hit his notification bell.
I don't need to do shit.
Yeah, I know. People like it when you waltz and like the Tomcat.
I know. I just like whatever. I just like show up. Look, a wizard is never late or early. A wizard arrives exactly when he intends to.
Sure. Alrighty, everybody.
Anyway.
Here's some bankruptcy music for you. Well, bankruptcy nonsense. We're out of here. Have a happy Saturday. I've got to work over the weekend, so unless something huge happens, I'll keep the weekend to myself other than what I have to do for work. So until next time, which will be any day, because that's the way this goes. And if we get bored, maybe we'll come back with some ginger bites. Because
that's still queued up. I'm ready. I've got it. The AI's already done the thing.
Yeah. There you go. All right, folks.
Okay.
So,
bye.
He offer some clarification because he helped me answer that question. David?
In the end of the video, you were talking about, Laura, I hope that you never pay Clayton. You could file a bankruptcy. Either way, there's no legal requirement for you to post bond if you don't have the money to be collected. Didn't Laura admit to having $200,000? Where did that money go? What do you mean she doesn't have any money? You don't want her to pay? You're telling your client, hey, ignore this payment of $150,000.
Maybe David could offer some clarification because he helped me answer that question. David?
Laura does not have any money, okay?
I mean, I haven't ever in my life had like a 1099 or W-2 job, really been supported by my family.
Her income has basically been destroyed, and she blames JFC for this. She says that JFC has, harassed her podcast advertisers to the point that they won't work with her anymore, and her income is basically zero now. And she never said that she made $200,000. What she said was that was what the podcast made, and she split that with her mom.
Testified on March 1st, 2024, that the horse business, Quartet, made $144,000 of income, and that was split between you and your mom. Do you recall testifying to that?
So the $200,000 that she said at the trial, she no longer has for whatever reason.
She was saying that was her income from the podcast that she was doing with her mom.
But you didn't report that on your bankruptcy, your sworn bankruptcy.
Her income is zero, basically zero. Her assets, they are what they are. Clayton is entitled to go and look for that. Dude, he can collect his judgment all he wants.
Maybe David could offer some clarification because he helped me answer that question. David?
I said to her a while ago, just if you file bankruptcy, you don't have to deal with this anymore. You just push that red button on your desk that says, boop, I'm done, bankruptcy. The entire case goes away. Clayton's ability to do anything to her in court anymore stops the minute she files bankruptcy. And she won't do it. And she said, I'm not going to do that as much as it would bring her relief.
Maybe David could offer some clarification because he helped me answer that question. David?
But don't say that I'm encouraging her to ignore an order. She's not sitting on $10 million in cash and I'm just saying to her, go hide that. She doesn't have the money.
Maybe David could offer some clarification because he helped me answer that question. David?
Don't say that I'm encouraging her to ignore an order. I said to her a while ago, just if you file bankruptcy, you don't have to deal with this anymore. You just push that red button on your desk that says, boop, I'm done, bankruptcy. The entire case goes away. Don't say that I'm encouraging her to ignore an order. If you file bankruptcy, you don't have to deal with this anymore. And she said, I'm not going to do that as much as it would bring her relief.
But you didn't report that on your bankruptcy, your sworn bankruptcy statement.
And she said, I'm not going to do that. And she said, I'm not going to do that. And she said, I'm not going to do that.
David was my attorney. David signed the pleading.
The fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
She has become a friend. I talk to her often. I have spent a lot of time with her, way more. I mean, you guys have no knowledge that I do as far as contacting with her personally.
Maybe David could offer some clarification because he helped me answer that question. David?
I talk to her often. I have spent a lot of time with her.
David was my attorney. David signed the pleading.
I have spent a lot of time with her.
The fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
Maybe David could offer some clarification because he helped me answer that question. David? 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 David?